6497 डाला
From very list or judgment
आपका
at
judgment
1.
second half में होगा. It is under correction. Your case is under correction. Second half में होगा. Second half. Okay.
For judgment item 1, WPS 6497 of 2016.
In view of the findings, no fresh inquiry could have been instituted against the petitioner by the disciplinary authority. The impugned orders arising out of such fresh inquiry cannot be sustained in the eyes of law and is accordingly set aside. However, the disciplinary authority certainly could have differed with the findings of the inquiry officer by referring to the materials in the inquiry report dated 19/10/2011. The matter is remitted to the disciplinary authority to take appropriate steps in accordance with it.
From supplementary list for fresh filing item 1, WPS 140 of 2023.
The petitioner is found for direction on the respondent for payment of each full pension and gratuity, like computing the period from the initial date of each appointment till the date of the restatement.
They have filed a favorable counter affidavit.
Yes, counter affidavit has been filed.
They have filed a favorable counter affidavit.
They have not counted for the period. They have said, my lord, in the counter affidavit that no work, no pay. I have seen.
Where is it? No work, no pay. They have all fixed your pension, your revision pension has been fixed.
Annexion B can be seen of the last counter affidavit.
Yes.
That is was received by me on 20th to 2024. The last one.
Where is no work, no pay?
I'm sorry, that is of 28/6/2023.
19/2/2024. इनको दिखाइए 10 मिनट बाद टेकअप करिए 11 बजे इसको देख लीजिए.
Item 2, WPS 1382 of 2023.
My notice जो इसके आज के लिए पास ओवर कर दिया जाए उसको मंडे के लिए रखे जाए मंडे
WPS number 1382 of 2023. Counsel for the parties are present. Counsel for the respondents is directed to seek instruction and file a counter affidavit in the present case. By इसको ऐसे लिखे. Let the counter affidavit be filed by
4 weeks time.
काउंटर एफिडेविट सिर्फ आपको देखिए सारा चीज आपके रिकॉर्ड में है. इसमें सारा कुछ इसमें लगा हुआ भी है. लेकिन काउंटर एफिडेविट इसलिए आपसे पूछ रहे हैं बिना आपको सुने अलाउ नहीं कर सकते. ठीक है, बता दें इसीलिए बाय 1st of May आप कर दीजिए. पोस्ट दिस केस ऑन 7th of May 24 इन द सप्लीमेंट्री कॉस्ट.
Item 3, WPS 1621 of 2023.
Petitioner. Who is for the respondent? Where is the petitioner? What do you have to say?
Madam, this petition has been filed. They have filed to cause the order dated 7th December 2007. Basically, the petitioner was habitual in absenteeism, madam. So, show cause was issued, and the petitioner he chose not to appear before the inquiry committee, ma'am.
The petitioner was advised to raise industrial dispute as per page 36. फाइल नहीं पढ़ते घर में.
I pray that this matter will be passed over the Lord's. Actually, Mr. Prashant Prasad has to argue this matter with Lord's.
Why didn't you pray for the Passover immediately? You have not read the file. You can't answer one question. Call Mr. Prashant Pallab at 11 o'clock. Next. Passover करते हैं, 2:15 बजे टेकअप करेंगे. ये जो पिटिशनर हैं, इनके वकील का नाम लगेगा.
Item 4, WPS 1744 of 2023.
WPS number 1744 of 2023. Counsel for the respond number 3 to 5. 3 to 5 की तरफ आप है ना? 3 to 5.
JPS.
5 है JPS.
Yes.
3 4.
University.
Counsel for the respond number 3 to 5. Counsels for respond number 3 to 5 are directed to seek instruction and file a counter affidavit. State की तरफ से कोई नहीं है. Three to 5. Mr. Mehta, are you appearing?
I am appearing for the university.
Okay, that is 3 and 4.
Yes, Your Lordship.
You file a counter affidavit. Let the
Respondent number 1 and 2 was already filed. That's all.
मैंने बोला respond number 1 and 2 को counter file करने के लिए.
Because you-
नहीं बोला ना?
Because state was called for that. So
Unnecessary. बिना बोले मन नहीं भरता क्या?
I apologize.
Let the counter affidavit be filed by 3rd of May, rejoinder if any by 17th, post on 12th June under the heading of admission. Next.
Published.
Item 5, WPS 1798 of 2023.
Following this case, the petitioner prays for direction upon the respondent to consider the candidature of the petitioner for appointment on the post of part-time sub-staff.
Where is the respondent?
My lord,
This
when
part-time sub-staff perhaps has been eliminated.
The part-time sub-staff, my lord, actually because my lord, the petitioner has invited, respondent has invited application.
Have they made any selection? No.
No, he has completed, but has not been.
Because in principle, I think they have scrapped the concept of part-time.
My lord, similar matter has been fixed, your lordship, on 18th, my lord, in
Against the same bank.
Same bank, same.
When has been fixed?
WPS number 257 of 2023.
3 number?
WPS number 257 of 2023. This case has already fixed. my lord.
What is the date?
On 18th, my lord.
18/5.
But,
18/5.
but,
ये देखिए इसका ऑर्डर देखिए.
257 of
257/2023.
इसमें हम ही वकील थे, इसी में बहस किए थे, उसमें
ऑर्डर दीजिए जरा इसका.
रिजवाइंडर के लिए रखा गया।
उनकी तरफ से कौन वकील थे उस दिन?
उस दिन रोहित सिन्हा, रोहित कुमार। In that case, notices I already been received and counter affidavit I already.
रोहित रंजन सिन्हा. मिस्टर रोहित रंजन सिन्हा को जरा बुला लीजिए. उन्हीं को नोटिस एक्सेप्ट करा देंगे और उसके साथ उस दिन डिस्पोजल कर देंगे. सेम इशू है,
बोला
है ना? नोटिस का पैसा बचेगा ना?
मान लो
बुलाइए उनको, 2:15 बजे बुलाइए.
Item 6, WPS 1861 of 2023.
Petitioner.
Is an obstruction is a requirement that is limited to matter lordship. Possibly 8 petitioners are there and we filed an IA lordship for addition of more 5 petitioners.
How through IA more petitioners can be added? You have to file a separate writ petition. उनका specific averments होगा, सब कुछ होगा, whether they are moved, not moved, ये उनका court fees होगा. There are so many things. IA से intervention से आप oppose कर सकते हैं writ petitioner को petition को. You can't get yourself added as a party. WPS number 1861 of 2023 with IA number 4749 of 2023. The Learned Counsel for the petitioner submits that interlocutory application has been filed on behalf of 5 persons to be added as petitioners in this case. This court is of the considered view that such an interlocutory this court is not inclined to allow the interlocutory application, as each of the person who approached this court through the petition have to make necessary amendments regarding their cause of action, and other formalities like payment of court fees, etc., is also required to be complied. Accordingly, this IA number 4749 of 2023 is dismissed. However, liberty is reserved with the petitioners reserved with the persons who have moved IA to seek their remedy in accordance with it. और आगे कौन सा है? IA में जिनका नाम है, सबका नाम डाल दीजिए. What else? You have filed more IA.
Supplementary application. That is true for that.
There is one more IA. What is 3738? इसमें भी वही है, same है इसमें. 3738 में भी वही करेंगे. Okay, both the IAs. Yes, and what is your case? A counter affidavit has been filed in this case.
Yes, Your Worship. Counter is-
There is a direction issued by the Urban Development Housing Department to them to do the needful. That should be sufficient to dispose of the writ petition
Yes, Your Worship.
in light of the counter
Yes,
affidavit,
Your Worship.
isn't it?
Yes.
The WPS number 1861 of 2023. This writ petition has been filed for the following reliefs. उसमें जिसमें लिखे हैं ना, to take steps in accordance with law by filing a separate writ petition or by moving the appropriate authority. तो उनका काम ऐसे ही हो जाएगा, ठीक है? Appropriate authority for redressal of offence. इसी में लिखा. The Learned Counsel for the petitioners submit that the petitioners have retired from the service of Nagar Parishad Sahibganj on different dates. And after retirement, all the petitioners were getting their pension from Nagar Parishad Sahibganj. And the name of the petitioner also reflects in letter number 198 dated 6/2/2023. It is a case of the petitioner that from the date of their retirement, several years have passed, but till date, the respondents have not paid the amount of provident fund, gratuity, and leave encashment, for which the petitioners have approached the respondents on several occasions. The Learned Counsel also submits that, in this regard, Secretary, Urban Development and Housing Department, Government of Jharkhand, by letter dated 5/8/2021, had directed the executive officers of Nagar Parishad and other concerned authorities to pay gratuity, provident fund, and salary from the fund of the municipality. And thereafter, the petitioners have been filing their representations and raising their grievance before the respondent number? No, Nagar Parishad. Before the respondent number 3. 3 की 4 लिखे? Respondent number 4? Before the respondent number 3 and 4, but no action has been taken. The Learned Counsel has, you are for the state, you have filed your counter saying that they have to take a call.
Yes.
The Learned Counsel for the state has submitted that, as per the counter affidavit, the Urban Development and Housing Department, Government of Jharkhand, has issued another letter number 1571 dated 24/3/2023, directing the Executive Officer Sahibganj Nagar Parishad to file counter affidavit and has referred to and has specifically mentioned in paragraph 8 that in the light of letter number 2679 dated 17/12/2008 and notification number 973 dated 6/2/2017, a direction was issued to the urban local bodies by letter number 2541 dated 24/6/2019 that the decision regarding fixation of payment of pensions/gratuity of municipal employee are to be taken at the level of the concerned urban local body. He submits that the state has nothing to do in the matter and it is for the respondent number 3 and 4 to take a call and pass an order. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that certain post-retirement benefits have been paid to the petitioners, but a part of them has not been paid. And they have been representing before respondent number 3 and 4 for redressal of the grievances. But no decision has been taken. No adverse order has been placed on record. And therefore, this court at this stage is not inclined to issue notice to respondent number 3 and 4. As per the counter affidavit filed on behalf of the state, the matter is to be essentially taken up by respondent number 3 and 4, and the state government has nothing to do with the matter. Accordingly, this petition is disposed of, enabling the petitioner to approach respondent number 4 by filing a representation and a copy of the writ records, and upon filing of representation along with a copy of this order, the respondent number 4 is directed to grant an opportunity of hearing to the petitioners, to one representative of the petitioners, and pass a reasoned order in accordance with law as per applicable circular guidelines, etc. within a period of 4 weeks from the date of representation, the reasoned order be communicated to the petitioners through speed post. It is made clear that this court has not gone into the entitlement or otherwise of the claim of the petitioners, and it is open to the respondent number 4 to pass appropriate orders in accordance with them. The state petition is accordingly dismissed.
Item 7 wrongly listed. Item 8 WPS 2024 of 2023.
Item number 8 and 10 are similar matters. In this thing, the petitioner has superannuated from service.
10 पे दीजिए साहब.
And in 10 you will see by paragraph number 8 to the counter credit, you will see the responding state of Jharkhand has filed its affidavit and said that the government of Jharkhand naturally request has been made to all the universities.
So it is a matter of policy.
Yes, ma'am.
You cannot get it by default,
Yes,
right?
yes.
So we will just ask them to take a final decision.
That will do, you will see, may take care of paragraph 8 to the counter credit.
I'll take care of it. Who is there in serial number 10? You are there? You have filed your counter affidavit?
No.
Serial number 10.
Yes, it has been filed by state.
State has filed, you will see, university has not filed. It is
Need
this-
not. There is a communication to the all the universities to take a call.
You will see. Next, A page number 9 to the
देखिए.
State. I was seeing 8 is being
8 and 10 4. You have filed a counter affidavit
Yes.
saying that it is in the process of being decision making process is on, right? So how much time will the university take to do the needful?
already 1 year has last the date is of 9/4 years.
University has not forwarded the required information. First, the needful has to be done by the university.
The expenses which is to be incurred is to be calculated and it is to be
That's
forwarded.
We'll expedite. Who is for the university? You are there in both the cases. You do the needful. You don't keep things pending. Allow करना है, reject करना है, जो करना है, right? You can't keep things pending like this. देखिए. Learned counsel for the parties are present. Counsel for the petitioner submits that in WPS number 2024 of 2023 and WPS number 2029 of 2023, similar issues are involved. Counsel for the respondents do not dispute this fact. Accordingly, these two cases have been taken up together. Prayer of WPS number 2029 of 23 is quoted as under, and prayer of WPS number 2024 of 23 is also quoted as under. Quote करिए. एक में आदमी रिटायर हो गया, एक में
अब ये भी रिटायर कर गया by now. But 2029 is 2024 has also retired by now.
Okay, the learned counsel for the petitioner has submitted that
Both.
the petitioner in WPS number 2024 of 2023 has also retired during the pendency of this case. The learned counsel for the respondent state has submitted that a counter affidavit has been filed in WPS number 2029 of 23, wherein a letter number 794 dated 5/4/2023 has been brought on record, which is issued by the Director Higher Education Government of Jharkhand Ranchi, whereby request has been made to all the universities regarding information related to grant of benefit of ACP/MACP. And the question of payment of arrears to it is for only non-teaching staff.
This one is
You are all non-teaching staff. To the non-teaching staffs of the university and its subordinate colleges till 31/3/2023 and the expenditure incurred on salary every year as per the detailed report enclosed with the letter. However, in WPS number 2024 of 23, a counter affidavit has been filed by referring to judgment passed by this court in WPS number 4403 of 2014 and analogous cases, which was disposed of by 27/2/2015, and it has been submitted that petitioners are not entitled for ACP and /MACP, as the same has not yet been made applicable to the employees of the university. The learned counsel for the petitioner has submitted that in view of the letter dated 5/4/2023 annexed with WPS number 2029 of 2023, it appears that the claim of the petitioner is under consideration and an appropriate policy decision is required to be undertaken, and therefore the information has been called for from all the universities. He submits that the letter has been issued on 5/4/2023, but the same has not been taken to a logical end, and therefore appropriate orders be passed so that the grievance of the petitioner is ultimately redressed. The learned counsel appearing on behalf of the respondent university, same university है दोनों में, respondent university has submitted that appropriate steps will be taken to comply the requirements to comply the letter dated 5/4/2023 if not already complied. He submits that no counter affidavit as such has been filed in the present case, and he is not aware about the present status of compliance of the letter dated 5/4/2023. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears from the letter dated 5/4/2023 annexed with the counter affidavit in WPS number 2029 of 2023 that the matter regarding ACP/MACP of non-teaching employees of the university is under consideration, and some information has been sought for from the universities. This court is of the view that at this stage, no mandamus as prayed for by the petitioner can be granted. Nay, at this stage, this court is not inclined to grant the relief as prayed for by the petitioner in this writ petition, as the matter is under active consideration of the respondents. However, the decision-making process is certainly required to be expedited. Accordingly, this writ petition is disposed of, directing the respondent university to expedite the matter pursuant to the letter dated 5/4/2023, if not already complied. If the necessary information in terms of letter dated 5/4/2023 has already been furnished to the state, then the state is also directed to expedite the matter and take a final decision within a period of 6 months from the date of receipt of the information in terms of their letter dated 5/4/2023. 6 months should be sufficient. This state petition is accordingly disposed of.
So no, but it goes without saying that if the benefit is to be extended.
अभी तो पॉलिसी आने दीजिए.
कंटेम्प्ट में उधर नहीं था तो फिर वो डिसीजन लेके बैठ जाएंगे.
कुछ ऐसा नहीं, 6 महीना का टाइम दिया है. पॉलिसी के लिए हम लोग बहुत ज़्यादा नहीं.
If they are going to take decision in our favor.
ऐसा नहीं, अभी नहीं, अभी कुछ नहीं. क्या डिसीजन होगा? एंटिसिपेशन में ऑर्डर्स नहीं होता. एंटिसिपेटरी बेल नहीं. चलिए. हाँ बताइए.
Item 1 WPS 140 of 2024.
देख लिए?
हाँ तो
आप तो फेवर में ही है ना?
हाँ फेवर में है, लेकिन
क्या
हमको
करना?
कंप्यूटेशन ऑफ द पीरियड जो है इनिशियल डेट ऑफ कॉरेस्पॉन्डेंट से 15 डेज हमारा जो री स्टेटमेंट हमको कंसीडर नहीं किया, उसमें साफ स्पष्ट लिखा हुआ है, तो क्लियरली स्टेटेड
कि नो वर्क
उस पे नो वर्क नो पे.
कहाँ लिखा हुआ है?
हाँ एंड बी है.
There was order to pay retirement benefits, your ladyship, but it has
That
been
is followed at
considered
page
as extraordinary.
Yes.
that is at page 22. It was updated 28/6/2023. सेवा अवधि का आकलन करते हुए सेवानिवृत्ति के उपरांत नियमानुसार देय लाभों को दी जाने का आदेश दिया जाता है. सेवा से बर्खास्ती अवधि
कहाँ पर आप पढ़ रहे हैं? हमको
हम ये जो आपके का उसमें भी है.
अभी जो नया काउंटर आया है,
काउंटर एफिडेविट में है.
कौन सा
Order
काउंटर?
है.
2 काउंटर है ना?
2 काउंटर है, ये सबसे पहला काउंटर है.
अच्छा, पहला काउंटर. बताइए.
इसमें है पेज 22.
20.
Restatement मेरा हुआ after passing of the order by this honorable court.
Where is the order of reinstatement?
That is followed.
Is there any order of reinstatement
No.
with all consequential reliefs?
No. This
तो
this
फिर
was
कैसे?
the order only that thereafter.
आपको ये consequential relief writ court से मांगना चाहिए. वो नहीं
This
हो
is
सकता.
the only order.
That will amount to modifying the order of the writ court itself.
And
We
that
can't do
question
anything.
or that I for that one I have also made prayer for recalling of that order to and to pass fresh order for the directing the respondent with regard to well of the
Writ का order का recall आपने फाइल
नहीं
किया?
हम उसमें नहीं, उसमें हमको उसमें नहीं था.
नहीं.
रिट का ऑर्डर लगाए हुए हैं एनेक्शर 1 है.
You see, now the point is that there is a punishment order.
Yes,
And they have got the discretion to deal as to how to deal with the intervening period.
Yes.
That discretion they have,
Yes.
and they have exercised their discretion.
But
We
they
can't
have-
do anything. Only on the quantum of punishment there was interference.
They have said
The punishment was-
they have considered that, but only that the back wages period.
इतना काफी है ना, pension मिल गया आपको, you should be happy about it, isn't it?
Period हमारा तो without any having fault, without having no fault on the
नहीं,
part
नहीं.
of the petitioner about.
No fault कैसे? Punishment is intact.
नहीं उसके
You
बाद
have-
जो ये जो
You
period
have been found guilty ultimately.
prosecution period में जो हमारे period from the date of or the passing of the order of dismissal till or the statement that the matter remain pending before this honorable court for 11 years.
11 years में क्यों यहाँ पेंडिंग था?
9 में हम आए, उसके बाद वो 21 में हमारा डिस्पोजल हुआ, डिसमिसल का.
आप क्या किए इतना साल?
तो हम तो ऐसे ही बैठे हुए थे.
आप ऐसे काउंसिल क्या किए? एक भी आईए फाइल किए फॉर अर्ली हियरिंग? कुछ नहीं. जब केस टेकअप होता है तो खाली टाइम मांगते हैं यहाँ पे. आप नहीं, आपको नहीं बोलते इन जनरल. लिखिए WPS नंबर 140 of 2023.
May I leave the room? Just.
This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner had earlier moved this court in WPS number 6070 of 2009 for prayer of quashing of order contained in memo number 92 dated 6/6/2009. SL. The learned counsel for the petitioner has submitted that the petitioner was put under suspension with effect from 6/9/1994 and was subjected to disciplinary proceedings. The order of punishment was assailed before Honorable Patna High Court in CWJC number 5839 of 1999 within bracket P. And after creation of state of Jharkhand, the same was transferred to this court and finally disposed of by the order dated 9/2/2009. By observing that the petitioner had not invoked the statutory revisional revisional remedy provided under the Act, and the respondents were directed to consider the same and also consider the issue of disproportionate punishment. Thereafter, fresh order was passed as contained in memo number 92 dated 6/6/2009, which was challenged by the petitioner in WPS number 6070 of 2009. And this court observed that the authority had not applied its mind and had just confirmed the punishment. And there was no finding with regard to quantum of punishment. And consequently, the order contained in memo number 92 dated 6/2/2009 was quashed and set aside, and the matter was remitted back to respondent number 3 with a direction to reconsider the appeal of the petitioner only on the quantum of punishment and pass fresh order. By this time, the petitioner had attained the age of superannuation, and therefore the entire exercise was to be completed by the appellate authority within a period of 4 months. The Learned counsel for the petitioner has submitted that a fresh order was passed taking into consideration the issue of disproportionate punishment. And thereafter, the petitioner filed his representation before the Deputy Inspector General of Police, Jharkhand, who considered the case of the petitioner sympathetically and order entitling the petitioner for his post-retirement benefits, including pension and gratuity, was passed, taking into consideration that the petitioner has already attained the age of superannuation in January 2021. And the order for payment of post-retirement benefits was passed by computing the period of service with effect from 27/8/1988 to 27/11/1988. And the grievance of the petitioner in the writ petition was that petitioner was not paid 90% provisional pension and gratuity, though the petitioner was entitled for full pension and gratuity on the basis of revised pay scale, that is 7th pay revision. It is the case of the petitioner in the writ petition that the matter remained pending before this court for several years, and during the intervening period the petitioner was not gainfully employed, and therefore the petitioner is also entitled for his back wages, including increment and other benefits of service. The learned counsel has submitted that during the pendency of the writ petition, the petitioner has been the learned counsel for the petitioner has submitted that the petitioner has been granted the post-retirement benefits, but the intervening period but no back wages has been granted to the petitioner for the intervening period from 27/8/1988 to 27/11/1999 on the ground of no work, no pay. And the same period has been adjusted against extraordinary leave. The learned counsel submits that the petitioner cannot be made to suffer on account of pendency of the case before this court, and therefore the respondents be also directed to grant full wages for the intervening period. The learned counsel for the respondents has submitted that the grievance of the petitioner has been fully redressed, and the petitioner has only been granted the benefit of modification of order of punishment but the fact that the petitioner was found guilty in the departmental proceeding has not been interfered by this court. She submits that at the time of disposal of the writ petition, there was no direction for payment of full back wages, and therefore the order passed by this court has been complied in letter and spirit, and admittedly the petitioner having not worked during the intervening period, the respondents have rightly exercised their power by referring to no work, no pay. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner was dismissed. He was earlier dismissed from service on account of departmental proceeding, but by virtue of order passed by this court, the order of punishment was modified, as this court was of the view that the point of disproportionate punishment was required to be considered by the respondents. Admittedly, the petitioner remained out of service during the period from 27/8/1988 to 27/11/1988, and the petitioner is alleging that the matter remained pending before this court for years together. However, and therefore the petitioner is entitled for full back wages. However, there is nothing on record to suggest as to what steps were taken by the petitioner for early disposal of the writ petitions. And further, the order passed by this court in WPS number 6070 of 2009 does not refer to any direction for the payment of back wages for the intervening period. Considering the admitted position that the petitioner did not work during the intervening period from 27/8/1988 to 27/11/1999, this court is of the view that the respondents have rightly exercised their power in refusing to grant back wages, and accordingly this court is not inclined to issue any further direction to the respondents to give back wages to the petitioners for the aforesaid intervening period under Article 226 of the Constitution of India. This petition is accordingly disposed of. बाकी तो प्रेयर हो गया ना?
Yes.
ऐसा लिखिए, the remaining benefits having been paid, this petition is accordingly disposed of.
Item 9, WPS 2028 of 2023.
Serial number 3rd, please for not.
This one?
No, supplement 3rd. Serial number 3rd,
2/15 के लिए पास ओवर हुआ, ऐसे बीच में घुस के नहीं बोल सकते. 2/15 पर आइए. Yes, petitioner?
Yes.
Let's the prayer in this is for quashing the process, entire process, by which selection of respondent number 8 was made on the post of Anganwadi Sevika. On a very sole ground, my lords, that the educational qualification that she possesses is of Fazil and Alim and Fazil. And I do possess masters from IGNU and graduation. So I have got the higher qualification. Now, nerds will kindly see why I make a claim on this. Page number 32.
You see, the matter is still pending before DDC. वहीं पे जाके आप लोग, the matter, it has not yet been approved as per the contract. पढ़िए, page number 6. क्या हम करें कि आप लोग फाइल पढ़ के आएं? What should I do? Tell me. ऐसा हम क्या करें कि आप लोग फाइल पढ़ के आएं? पेज नंबर 6 का बॉटम में है काउंटर. हर एक केस में एक अमाइकस अपॉइंट कर देंगे. बहुत अच्छा रहेगा. कोई तो होना चाहिए ना फाइल. पूरे जूनियर्स को एक फाइल मिल जाएगा पूरा हाईकोर्ट के. 10 फाइल फॉर ईच जूनियर, बिकॉज सीनियर डज नॉट हैव टाइम टू रीड द brief.
Here they say that she has been selected.
Page number 6.
Yes, ma'am. I got.
You have seen? तो वही जाइए. किसको बेटर क्वालिफिकेशन है, किसका क्या होगा. अभी तो फाइनली नहीं हुआ उसका सिलेक्शन. आप वॉशिंग के लिए चले. You hear the private respondent also. देखिए WPS number 2028 of 2023. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has better educational qualification than that of the private respondent.
I even say, my lords, that the degrees that she has provided, they don't stand as a degree, not recognized by the UGC. So
the learned counsel has also submitted that the degree, that the educational qualification of respondent number 8 do not satisfy the requirement of UGC.
Yes.
Norms of UGC. ऐसा कोई कंडीशन है क्या कि यूजी से एफिलिएटेड होगा तभी? आंगनवाड़ी इज अ वेरी डिफरेंट काइंड ऑफ.
हाँ, डिफरेंट है, बट आई विल जस्ट एक्सप्लेन. ग्रेजुएशन और जो पोस्ट ग्रेजुएशन का डिग्री है ना, दैट इज बीइंग गिवन बाय द यूजीसी. जितने भी यूनिवर्सिटीज हैं दैट कम अंडर दैट. अब ये कहीं से भी लेके आ जाएंगे तो होगा नहीं. इफ इट वाज टिल मैट्रिकुलेशन टिल 12th तो कहीं का भी डिग्री चल जाता है. बट अपार्ट फ्रॉम दैट व्हेन यू आर क्वालिफाइंग इन graduation,
the learned counsel appearing on behalf of the respondents has referred to para 7 of the counter affidavit and has submitted that the selection is still pending. Selection of the respondent number 8 is still pending for approval of the Deputy Development Commissioner.
If I but may I only be permitted because he may ask the DDC.
आप तो फाइल ही नहीं पढ़ के आए. आपका हम क्या करें?
ये जो काउंटर
नहीं, आपका हम क्या करें बताइए. Can I do anything about it?
It's of the 9th month.
I do not know.
If it is not finalized.
We do not know. अगर फाइनल हो गया तब आप उसको फाइनल ऑर्डर को चैलेंज करें. No rejoinder to the counter affidavit has been filed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears from the records of this case that the matter regarding selection is still pending for approval before the respondent number.
DDC is respondent number 5.
Respondent number 5. In such circumstances, this court is not inclined to entertain this writ petition at this stage. The petitioner may approach the respondent number 5, before whom the approval of the selection is pending by filing a representation and a copy of the writ records within a period of 1 week from today. The respondent number 5 shall grant an opportunity of hearing to the petitioner as well as respondent number 8 and pass a reasoned order in accordance with law, taking care of the applicable circular guidelines, etc. The reasoned order be passed within a period of 1 month from the date of representation and be communicated to the concerned parties. The state petition is accordingly disposed of.
May I request, if an order has already been passed, I may be allowed to prefer another date. Plus saving will happen.
Since the counter affidavit has been filed on 16/9/23, in case the approval has already been made, no fresh order need be passed, and it will be open to the petitioner to take steps in accordance with it. And the order confirming the order regarding approval be simply communicated to the petitioner through speed post. Communication भी जरूरी है आपको. क्या challenge करिएगा फिर खोजते रहिएगा order.
Item 11, WPS 2298 of 2023.
Counter call कर देते हैं. Choose for the respondent. File your counter.
That's 106.
Counsel for the parties are present. Who is it? Counter has to come from respondent number 6.
Yes. DSC Palam.
Why only DSC Palamu? The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. DSC पलामू का काउंटर एफिडेविट मत फाइल करिए. जो भी फाइल करेंगे आपको अलग से फाइल करना है करिए, बट काउंटर एफिडेविट हैज टू कम फ्रॉम सम हायर अथॉरिटी ऑफ रिस्पॉन्ड नंबर 2 who may seek the necessary information from the
DSC Palam.
From the respondent number 5 and respondent number 6. Right? The counter affidavit be filed by 3rd May. ठीक है? By 3rd May, rejoinder by 15th May. Post this case on 18th of June under the heading for admission.
Item 12, WPS 2586 of 2023.
Yeah, please, Your Lordship. Your Lordship, in this case, the petitioners before Your Lordship has prayed for a direction upon the respondent to consider their candidature for being promoted to class 3 post because they are working on a class 4 post. Your Lordship. They have filed a counter affidavit in paragraph number 10 and 17. They have said that the representation which were filed by the petitioner were not coupled with sufficient documents. So I will be praying, Your Lordship, if Your Lordship so desires, may direct the respondents to consider in terms of paragraph number 10 and 17 and the relevant rules and the guidelines which I have annexed with the memo of the writ petition, including one at annexure 3, Your Lordship, which is a circular of 1992, which suggests that all such persons who have rendered substantive period
No adverse order against you?
There is no adverse order. In fact, it's 10 and 17 there says page 14. One thing that I would be requesting only your Lordship, that they have referred to a rules of 2010, but in my humble submission, as per their document which I have annexed by way of rejoinder, that is not in force in the Department of Forest at present. So I would be praying your Lordship that rule may not be indicated. Only they will take in decision
Applicable rules.
applicable.
Whatever is
Yes,
applicable.
yes, that will yes, that is what I am saying.
Whatever is applicable,
Application.
whatever is adopted, you will only take
Yes.
those into consideration.
Yes, you are right.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioners
Business. Paragraph 5 I have given you.
has submitted that the details regarding each of the petitioners has been given in a table at paragraph 5 of the writ petition, and has submitted that all the petitioners were appointed on a grade 4 post under Dumka, Kodarma and Ranchi division under the Department of Forest, Environment and Climate Change, Government of Jharkhand, and are still in service. He submits that the petitioners being eligible in all respect and also having the minimum qualification were entitled for promotion, but their case for promotion has not been considered in spite of vacancies everywhere. The learned counsel submits that a counter affidavit has been filed in the present case, mentioning that although the petitioners had filed representations for being promoted to class 3, but since they did not provide the documents regarding their educational qualification and other documents showing their eligibility, their case would not be considered. The learned counsel has also submitted that further stand has been taken in paragraph 17 that if the petitioners possess the minimum eligibility criteria as per the rules, they may apply for appointment in class 3 post through limited examination and then appear in the limited examination which, when it is next conducted by Jharkhand Staff Selection Commission. And the question of promotion will arise only if they become successful. It has been also asserted in the counter affidavit that the rules relied upon by the petitioners is not applicable to them. The learned counsel has submitted that a rejoinder has been filed to submit that as reported by the Chief Conservator of Forest within bracket non-gazette bracket close Jharkhand Ranchi by letter number 290 dated 5/8/2022. Not a single exam has taken place in last 23 years for promotion of Group 4 to Group 3, as no rules have been framed by the department. The Learned Counsel submits that the petitioners are entitled for promotion on the basis of seniority cum merit in terms of letter number 335 dated 16/9/1992. The Learned Counsel submits that there is a dispute has been raised in the present case regarding the applicable circulars in the matter of promotion, and since no adverse order has been placed on record, appropriate direction may be issued to the respondent number 7.
You let it be high ranking is 2.
To the respondent number 2 to pass a reasoned order in accordance with law
High ranking.
and act as per applicable law. ठीक है? After hearing, the Learned Counsel for the respondents has submitted that the petitioner may approach respondent number 2, who shall look into the grievance of the petitioner. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case and the nature of the writ petition, this court is of the considered view that ये इतना सारा LPA वगैरह क्या फाइल किया?
तो जो इससे पहले इस कॉम्पैशनेट अपन ग्रेड 4 के लिए इनका रिकमेंडेशन हुआ तो फिर 3 के लिए गए तो लेकिन हार गए.
Yes. Considering the nature of grievance and the dispute which has been raised in connection with the applicable circular, and as to whether one of the other circular is applicable to the responding department, this court is not inclined to grant the relief as prayed for by the petitioner in this writ petition at this stage. However, the petitioner may raise their grievance before the. However, this writ petition is disposed of, enabling the petitioners to raise their grievance before the respondent number 2 by filing a representation and a copy of this order and a copy of the records of this case. And upon filing such representation, the respondent number 2 is directed to look into the grievance of the petitioner and pass a reasoned order within a period of 3 months from the date of the representation. The reasoned order be communicated to the petitioners through speed post. Reasoned order में लिखिएगा, making it clear as to the circulars and decisions of the government which are applicable to the petitioner, and mode and the manner in which the petitioners could be entitled for promotion.
Item 13, WPS 2632 of 2023.
There's an alternative remedy. They should have, of course, the central administrative tribunal.
That liberty may be given. I will not.
Why didn't you dispose of his appeal?
Yes.
Say his first prayer.
I know, that can also be done. But the point is,
I will not pass any order, but you do the needful. You just listen to the order. At least you are supposed to dispose of the
I have no
appeal.
difficulty if your lordship directs, but the only point
I
is,
will take care of that. You just
yes, your lordship may take care of the jurisdiction.
I will take care of the jurisdiction.
I have no difficulty with the order that you must dispose, if not disposed of.
If not disposed of, such WPS number 2632 of 2023. Learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the respondents has raised a preliminary issue regarding the maintainability of the petition, and he submits that the petitioner has an appropriate remedy before Central Administrative Tribunal, and therefore the present petition may not be entertained. The learned counsel, however, the learned counsel has submitted that looking into the grievance of the petitioner, if the appeal has not yet been disposed of by the respondents, there can be no problem in disposing of the appeal.
No. Right? Yes, ma'am. Appeal has to be disposed.
After hearing the learned counsel for the parties and considering the aforesaid submissions, this court is not inclined to entertain this petition on account of availability of alternative remedy to the petitioner through Central Administrative Tribunal.
But that notification is also there.
Please be clear, the petitioner does not dispute that the counsel for the petitioner does not dispute that the petitioner has a remedy under Central Administrative Tribunal. Uske baad this court is not inclined to entertain the present writ petition. Transfer order भी challenge कर दिए नहीं?
It is by way of a punishment, my lord. It is by way of punishment. On the same date, my lord, penalty was imposed and transfer order was issued.
However, the petitioner may avail his remedy in accordance with law as permissible under law. Limitation हम कंट्रोल नहीं करेंगे.
मतलब नहीं लिबर्टी खाली दे दी है.
लिबर्टी बोलते उनका अंडरटेकिंग रिकॉर्ड करते हैं that he has undertaken if the appeal has not been disposed of.
Yes.
Mandamus नहीं इशू कर सकते ना.
Yes.
This writ petition is accordingly disposed of.
Item 14, WPS 2699 of 2023.
Unless the petitioner was parking as a driver has been attached to a car. So they say that the car has become defunct, that way you must also become.
आपका खुद से खराब हो जाएगा तो आपको भी निकाल के बाहर कर देंगे.
They're treating the car must be high maintenance like an elephant. So elephant का महावत होता है, elephant death.
Yes.
I am appearing on behalf of the state matter. The situation of the car is very dangerous.
The person is attached to the car or he is attached to an office.
Office.
आपके गाड़ी में चढ़ना बंद कर दिए आपके ऑफिसर लोग. कान बंद कर दिए हैं.
नहीं बंद नहीं किए.
फिर you don't need him anymore. How many years of service have you taken from him?
13 years.
13 years. उसका कहाँ जाएगा बंदा? Ad hoc है.
हाँ.
What relief are you seeking?
Yes, challenging that order by which I have been removed, but that ultimately.
What right do you have?
Ultimately, regularization also. Prayer B is regularization.
Are you covered by some scheme?
This scheme is the government of Jharkhand, same scheme. The government of Jharkhand has issued a scheme.
You have not completed 10 years.
Yes, ma'am.
Yeah?
13 years.
No, 13 years on the cutoff date.
2009 onwards, 2019 is the regularization extension.
You file your counter.
No, madam. In section
file
number-
it?
Yes.
Okay. Okay, WPS number 2699 of 2023. The learned counsel for the parties are present. The learned counsel for the petitioner submits that after taking work from the petitioner for more than 13 years, the respondents who was working as a driver, the respondents have discontinued the service by stating that the vehicle itself has become defunct. The learned counsel submits that an employee is attached to an office and not to a vehicle. He has also submitted that otherwise also the claim of the petitioner is fit for consideration in terms of the applicable regularization scheme. Disposal कर दें?
ये order set aside नहीं होगा तो कभी regularize नहीं होगा.
Okay.
Contempt.
Just a moment. The learned counsel by the respondents is directed to seek instruction. No, this court is of the prima facie view that an employee is attached to an office, not to a vehicle. However, the learned counsel for the respondents is directed to seek instruction and file a counter affidavit if the case of the petitioner can be considered for the purposes of regularization if the petitioner is otherwise found entitled as per applicable scheme. ठीक है? Let the counter affidavit be filed by. बहुत छोटा काउंटर है, ठीक है? आप ऐसा नहीं कर सकते. किसी का गाड़ी डिफॉल्ट नया गाड़ी खरीदी है, कितना सरकार का खरीदे है ना, उसके लिए दूसरा ड्राइवर रखिए.
हाँ.
Very unfair. Let the counter affidavit be filed by 30th April. कौन फाइल करेंगे? काउंटर कौन फाइल करेंगे?
The order was passed notes by the Ayukt, Commissioner, Commercial Taxes.
Principal Secretary, no. Respond number 3 perhaps.
Then I think it should be filed.
Principal Secretary.
No, I think yes, Principal Secretary.
Who has passed out?
The additional Commissioner, Respondent 3. I think
Respondent number
Respondent 3.
Yes, the counter of let the counter affidavit be filed by 30th of April 2024 by respond number 3. उन्हीं का काउंटर से हो जाएगा?
हाँ, हो जाएगा.
By respond number 3, post this case on 1st of May in the supplementary cause list. 1st May को रख रहे हैं. Labor Day है.
हाँ, yes.
Labor Day.
30 तारीख तक फाइल करना.
30 तारीख तक फाइल करिए. 1 तारीख को हम सुनेंगे. लेबर डे में कुछ अच्छा काम करिए. कुछ अच्छा काम आप ही करिए.
Item 15, WPS 2884 of 2023.
May it please the Ladyship, this petition is essentially for compassionate appointment, but there is some peculiarity in between matter. Ladyship, my mother-in-law was appointed.
What was her date of attaining the superannuation? She died after that date or before that date?
Your Ladyship, let me clarify. So the retirement age is 62 years. So I understand in the year 2017, they asked for age of proof from my mother-in-law, against which she provided her Aadhaar card. As per her Aadhaar card, Your Ladyship, she will turn 62 on.
That is not correct. At the time of appointment, you had disclosed your school transfer certificate.
Yes, Ladyship, very interestingly, it may come to school transfer certificate. The school transfer certificate reflects my date of birth as 16th October 1958. So if my date of birth has been 16th October 1958 and they have considered this, I would have, my mother-in-law would have turned 62 on 16th October year 2020. Now your Lordship, come to the impugned annexure, that is annexure 1 as page 15 of the petition.
Yes.
Lordship, as per this document, they are stating that the age of proof that they were having of my mother-in-law had turned 62 years on 1st March 2023. And now they are saying that they are relying on the school transfer certificate. And they have drafted the counter affidavit in such a mechanical manner that again they are repetitively they are stating that my date of birth as per my school transfer certificate is 16th October 1950 and I have turned 62 years. My mother-in-law has turned 62 on 1st March 2023. This, Your Lordship, reflects that this is an afterthought that they are relying upon.
Did you rely upon your school transfer certificate at the time of appointment?
Your Lordship, if this
Yes or no?
Your Lordship, I am not aware because mother-in-law is already expired and I gave a representation and they asked for a proof of birth in the year 2017. I have stated.
You are aware that mother-in-law was asked for a proof of birth?
Your Lordship, I have stated yes because I was supporting my mother-in-law in carrying on the work and I have stated in the affidavit and they have very clearly admitted that this is a matter of record. That I was asked for this age of proof, I provided my Aadhaar card and they have admitted that this is a matter of record.
Verbal submissions and verbal exchanges are not matter of record. Right? If you say something, you have to prove it. We cannot decide what your mother-in-law has said. But the very fact that you obtained your appointment on the basis of school certificate at the time of appointment, it cannot be changed by virtue of Aadhaar card.
Ladyship, but they are saying that I turned 62 on 1st March.
Maybe. Whatever you have continued, you have been paid, that's it.
Ladyship, but this reflects that they are acting as per their whims and fancies and now when I have filed
you have no right.
Filed the writ petition.
Compassionate appointment is something, otherwise also you don't have a right.
Ladyship, you must take note of this fact.
We'll take care of everything. Don't worry about it. आपको क्या बोलना है?
In both the case, she died after his return.
Both the case.
In the impugned order, the date which has been mentioned, March 23.
From where do you put on this date? 1/3/23.
वो clarity इसमें नहीं आ रहा है, लेकिन that date is also after his date of his retirement.
What is the date of death?
Date of death is in April.
What is the date of death?
15 April 20.
April
15/4/23. The learned counsel for the parties are present. This writ petition has been filed for the following relief.
The second argument is she is mother, she is daughter-in-law of the deceased. Like his son is not mentioning his son is.
आंगनवाड़ी सेविका में सन को अपॉइंटमेंट देंगे क्या? थोड़ा तो दिमाग लगाइए. Compassionate appointment का रूल बनाए हैं. But who would be entitled as per your scheme? Bahu is entitled. Even daughter is no married daughter is not entitled. वो सब तो बेकार वाला बात है लेकिन. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the mother-in-law of the petitioner was appointed as Anganwadi Sevika as back as in the year 1985 and continued to work, and a letter dated 27/3/23 was issued to her whereby she was relieved from service by stating that she had already turned 62 years on 1/3/2023. The learned counsel submits that immediately thereafter, the mother-in-law of the petitioner expired on 15/4/2023. He submits that as per Aadhaar card, her date of birth is of the year 1963 and she would have turned 62 years only in the year 2025. And the reason for challenging the order dated 27/3/2023 is that if the mother-in-law would have continued in service and died on 15/4/2023, the petitioner would have been entitled for compassionate appointment. The learned counsel for the respondents, on the other hand, has submitted that a counter affidavit has been filed in the present case, mentioning that as per that at the time of appointment, the mother-in-law of the petitioner had submitted school transfer certificate dated 30/6/1986, wherein the date of birth was mentioned as 16/10/1958, and therefore she had already completed 62 years as on 1/3/2023, and the moment it came to light of the respondents, they issued the impugned letter dated 27/3/2023. He submits that during her lifetime, the mother-in-law of the petitioner never protested and never challenged the same. And after her death on 15/4/2023, the petitioner is challenging the retirement of her mother-in-law in terms of the impugned letter. To this, the learned counsel for the petitioner has submitted that if the date of birth of the mother-in-law of the petitioner is taken as 16/10/1958, she would have retired long back in the year 2020 itself. The very fact that her mother-in-law continued to work till 31/7/2023 itself indicates that the date of birth of the mother-in-law of the petitioner was taken to be what was recorded in the Aadhaar card and not in terms of school certificate. After hearing, however, no rejoinder to the counter affidavit has been filed. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, as per the counter affidavit, the mother-in-law of the petitioner was having date of birth as 16/10/1958, which was recorded in her school transfer certificate dated 30/11/1986. This fact has not been disputed by the petitioner while filing a rejoinder. Further, it appears that if date of birth is taken as 16/10/1958, the mother-in-law of the petitioner continued even beyond 62 years and was made to retire only with effect from 1/8 ki 1/3 with effect from 1/3/2023. However, the circumstances under which she continued to work beyond 62 years, if her date of birth is taken as 16/10/1958, is not clear. However, the fact remains that the mother-in-law of the petitioner during her lifetime never protested against her retirement on 1/3/2023, and she expired only on 15/4/2023. From the perusal of the writ petition, it appears that at the time of induction, way back in the year 1985, 85 में आधार था क्या? Way back in the year 1985, the basis for induction of the mother-in-law of the petitioner was the school transfer certificate dated 30/11/1986, wherein her date of birth was mentioned as 16/10/1958. In such circumstances, the mother-in-law of the petitioner having expired after her date of retirement, after completion of 62 years and date of retirement as per the respondent as 1/3/2023, the petitioner is not entitled for any compassionate appointment, and therefore this court is not inclined to grant the relief as prayed for by the petitioner in this writ petition. However, it is observed that a stand has been taken by the respondents in the counter affidavit that the petitioner does not come within the meaning of dependent as per the rules of as per the scheme for compassionate appointment, since the mother-in-law of the petitioner had expired after attaining the age of superannuation. This court is not inclined to pass any order in connection with the aforesaid stand of the state government.
I wanted to say the necessity of compassionate appointment. He did not disclose that his husband was working somewhere else or not. So necessity of compassionate appointment is not.
Necessity or entitlement?
Entitlement also and necessity to meet the financial crisis, sudden financial crisis.
Entitlement and necessity.
From daily list for final disclosure item 3, the rupees 5572 of 2016.
My case is that initially 13 persons were recommended by the Superintendent of Police for grant of this prestigious medal, that is President's Medal.
Just a moment. Is this the case of the respondents that your name was left out by mistake?
It is the case of the Union of India, as stated in the counter affidavit, that the state government has sent the second recommendation after a delay of 10 years, and they have not stated the reason as to why this delay occurred, and therefore their cases have been turned down. So my humble submission would be that, my lord, if I was entitled for, if I was similarly placed, as you granted to 4 other persons in the year 2010 itself, then if I was also similarly placed, if you would have sent at that time only, which you did after so many years, again, you rectified your mistake, but you elapsed much
So how can your award can be granted? It's a presidential award.
Yes, but
how a person's name can be added in the presidential award which was already been granted in a particular year?
Yes, I may clarify, my lord. In several instances, this has happened.
Several instances. आप order दिखाइए, हमको दिखाइए कि
order हम दिखा रहे हैं. एक order तो मेरे rejoinder में लगा हुआ है coordinate bench का, जिसमें it was held. उसमें थोड़ा सा ये difference था कि उसमें वो लोग decision नहीं लिए थे.
फर्क है ना?
हाँ, delay था.
It can't be. You see, it just can't.
मतलब
I just can't ask the honorable president to give you an award.
President does not give, my lord. It is only the SP which recommends, and after the clearance of
it is known as presidential award.
Yes, it is granted.
We cannot ignore that name, isn't it?
But
it is ultimately basically given by the honorable president only.
Yes, in her name or his or her name, ma'am. It is being delivered on 15th August.
मेरा एक केस बस इतना ही है माय लॉर्ड, सिंपल सा केस बस इतना है।
आपका सिंपल केस है, लेकिन मेरे लिए ये ऑर्डर पास करना बहुत कॉम्प्लिकेटेड।
ठीक है, दो रीजन हम बस मेरा सुन लिया जाए।
हम मान लेते हैं कि आपके साथ बहुत अन्याय है,
हाँ मैं
but still this cannot be. You can have compensation, you can have many things, but not the award. I cannot
ठीक है,
give
you
you the
grant
award.
me
like this.
let them grant me out of 10 promotion because that is one aspect of the president's medal what happens as per rule 60C out of 10 promotion मिलता है। तो why because of their lacuna and because of their fault we should
कोई
suffer?
आपका बहुत अच्छा भी नहीं था।
नहीं मेरा अब सेकंड रिकमेंडेशन हम पढ़ा दे रहे हैं एक बार बस माय लॉर्ड
नहीं, I will not issue a
पेज
mandate.
81 for a moment, one paragraph only I would place my lord, only one paragraph. Second recommendation, my lord, if my ladyship please peruses one paragraph of page 81, the second recommendation which has been sent by the SP after delay, what he says कि ये सारे लोग भी equally वहाँ पे थे और equally participate किए थे, 150 लोगों से हम लोग encounter किए थे my lord.
Page number 81 के bottom में है।
Yes my lord.
The other participants in the joint operation did not show any specific.
No 81 I am placing page 81.
81 में ही हम। वही खोल के बैठे।
On the basis of my verification and to the best of my knowledge of these under consideration, I fully agree with the recommendation originally sent by the then recommending authority and find no reason to justify any separate recommendation for the same, as the teamwork and gallant action of police in this encounter could not have been possible without the exemplary valor and leadership of these all 13 originally recommended personnel for PPMG. I am hereby strongly recommending the names of remaining 7 persons for PPMG, excluding the name of one police person, Roop Narayan Singh, because he has been dismissed from service on disciplinary ground. So it is clear, my lord, that they intentionally, my lord, brought our name without any reason, and now they are supplementing कि नहीं उस समय आप लोग बहुत अच्छा काम किए थे, 13 लोग मिलकर पूरा नक्सली से लड़ गए थे अकेले. So why this after so many years? And if this was to be sent in 2008 and 9, my lord, then our case have been different. हम लोग को मिल जाता, हम लोग को ये उसी समय कंसीडर हो जाता है.
यूनियन ऑफ इंडिया के लेवल पे कोई स्क्रूटिनी नहीं होता है,
कोई
बाय डिफॉल्ट मिल जाता है.
यहाँ से जब क्लियर हो जाता है होम से, यहाँ से होम से डिपार्टमेंट
बिना
से
स्क्रूटिनी के बाय डिफॉल्ट मिलता है.
यूनियन के ऑर्डर से तो यही दिख रहा है, मान लो एक बार यूनियन का ऑर्डर
बाय
जो
डिफॉल्ट
impugned
यूनियन
है,
ऑफ इंडिया में कोई काम नहीं होता.
वहाँ मैजिस्ट्रियल इंक्वायरी रिपोर्ट मंगाया जाता है, मान लो मैजिस्ट्रियल इंक्वायरी रिपोर्ट,
some scrutiny is done, no?
Yes, it is done. मैजिस्ट्रियल इंक्वायरी रिपोर्ट जाता है, वो भी यहाँ से चला गया, यहाँ से सब कुछ क्लियर हो गया. वहाँ पे डिनाई हुआ बस इस ग्राउंड पे कि आप डिले किए हैं स्टेट गवर्नमेंट, उसका कारण नहीं बताया. स्टेट, नॉट अस.
स्टेट विल कॉम्पनसेट यू, लेकिन उसके बियॉन्ड हम क्या कर सकते हैं?
And second thing, union has turned down our case without any assigning any reason. उनका जो impugned order है,
that reason is sufficient.
रीजन तो है ही नहीं कि your
कोई
case is
रीजन
being
है
turned
कि
down.
टाइम से नहीं आया आपका.
वो स्टेट वो भी नहीं लिखा ना, ये तो सप्लीमेंट कर रहे हैं.
Union of India has simply said that you have missed the bus.
No, they have said this in counter affidavit, not in the impugned order. Impugned order में तो कुछ है ही नहीं, बस इनका केस टर्न डाउन किया गया, बस इतना ही.
टर्न डाउन कर दिया तब तो और सीरियस है. टर्न डाउन कर दिया इसका मतलब इन स्पाइट ऑफ रिकमेंडेशन योर केस हैज बीन टर्न डाउन.
लेकिन
वेरी सिंपल कहा इन योर यूनिट.
यस, यूनियन का impugned order हम दिखा रहे.
बस
This is page
रीजन देने का कोई जरूरत भी नहीं.
107 और रीजन को सप्लीमेंट किया यूनियन ऑफ इंडिया, रीजन बताया कि क्यों, तो वो स्टेट गवर्नमेंट का डिले था, ये स्टेट गवर्नमेंट को कारण नहीं बता रही है डिले का, इसलिए हम नहीं कर रहे. सो दिस इज ओनली केस कि स्टेट के लैकुना की वजह से व्हाई वी शुड सफर. माय लॉर्ड, व्हेन वी वर इक्वली प्लेस्ड एवरीथिंग, सब कुछ दो बार रिकमेंड हुआ, हेडक्वार्टर से, पुलिस, डीजीपी, सब जगह से, उसके बावजूद इनके डिले की वजह से हम लोग को नहीं मिला. बस
उसके लिए तो आपको सूट फाइल करके कुछ कॉम्पनसेशन रिकवरी करना पड़ेगा. कैसे क्या होगा बताइए. Why should he not be compensated for your delay?
Already, the first recommendation was sent by the state government to the union
including all 13 persons.
No, Your Lordship.
Then?
Because initially the state government had recommended only 4 persons, Your Lordship.
Why?
Because they were.
And subsequently you say that they were equally participants and they are equally entitled. Why did you at all send the recommendation in the second place? What was the occasion to send you the recommendation again? Who will compensate them?
The Lordship has, while order dated 15.
I will not ask you to give any medal or award. but I will certainly ask you to give some compensation.
The Lordship has, while order dated 15/3/2024, has inquired the petitioners how this claim of the petitioner to grant presidential award.
Certainly, we will not grant that relief, but they are entitled for some compensation for your delay and latches. Have you explained your delay and latches, and have you explained that why initially their name was left out?
There is no such government.
There is no such government, so you pay.
There is no prayer in the writ petition for grant of compensation.
Need not be. I'll pass an order. You just file an affidavit as to why they should not be compensated. I'll give you an opportunity before I ask you to compensate. Then you will come up. आपको बिना सुने ऑर्डर नहीं करेंगे, इतना गलती नहीं करते हैं, right? You file an affidavit explaining the reason for leaving out the name of the petitioner at the first instance. And if you give some reason to leave it out, then what was the reason to send it again? The learned counsel for the parties are present. The learned counsel for the petitioners has submitted that altogether 13 persons were equally placed in the matter of consideration for grant of presidential medal, but name of only 4 persons was selectively sent without assigning any reason to leave out the remaining. The learned counsel further submits that later on, the name of the remaining persons were also sent, but their case was turned down by Union of India by impugned communication dated 18/2/2016 without assigning any reason. However, the Union of India has filed a counter affidavit stating that there was delay in sending the recommendation, and therefore the case of the petitioners could not have been considered. The learned counsel submits that the respondents have not assigned any reason for leaving out the name of the petitioners while sending the initial recommendation. And pursuant to the initial recommendation, 4 persons have been given the presidential medal with the consequential service benefits of promotion, increments, etc. The learned counsel submits that leaving out the name of the petitioners while sending the initial recommendation has a serious impact on the service benefits of the petitioner, and therefore the impugned action of the respondents and impugned order of the Union of India calls for interference. In the alternative, he has submitted, in the alternative, he has submitted that at least the petitioner should be suitably compensated by the state government on account of their acts and omissions with regard to the entitlement of the petitioner. He has submitted that nothing can compensate for the prestigious presidential award, but considering the facts and circumstances, appropriate order for compensation be passed. The learned counsel for the state is directed to seek instructions and file an affidavit explaining the reason for not sending the name of the petitioners at the first instance, and under what circumstances and what further consideration the name of the petitioners were recommended in the second instance. The learned counsel, the affidavit should also disclose as to why the petitioners be not suitably compensated by the state government and what would be the suitable compensation amount which, as per the respondents, can be deemed proper in the facts and circumstances of this case, considering the monetary loss which the petitioner has suffered on account of acts and omissions of the state. कितना टाइम आपको चाहिए और कौन एफिडेविट फाइल करेगा बताइए. Let the supplementary counter affidavit be filed by
DGP would be respondent number 6.
respond number 4.
Yes, 4.
Respond number 5.
5 Home Secretary. Yes, 5. Within 4 weeks.
आपको हम 4 नहीं आपको 8 weeks टाइम लेकिन सूटेबल और इक्विटी को देखते हुए फाइल करिए क्योंकि हमारे ऊपर छोड़ दीजिएगा तो हम फिर अपने हिसाब से फिक्स करेंगे. ठीक है. मॉनेटरी लॉस को देखते हुए एक क्वांटम जरूर लिखिएगा. मे बी विदाउट प्रेजुडिस यू कैन राइट बट सम अमाउंट शुड कम. राइट. कौन फाइल करेंगे 4 की 5? 5 should file?
5.
The supplementary counter affidavit be filed by respondent number 5. By 24th of June. Post on 26th of June in the supplementary cost list. आप केस की तैयारी बहुत बढ़िया करते हैं. You prepare your case well. I've seen it. थोड़ा थोड़ा कभी कभी कुछ इम्पोर्टेंट फैक्ट छूट जाता है बोलने से. अच्छे से केस कंडक्ट करना है.
Orders to effect item for contempt civil 341 of 2020 along with item 5 and 6.
Contempt?
No, this was a contempt filed by the workmen alleging non-compliance.
Ah yes, you have done it.
I have done it once, but I should have pointed out last week, and this is a mistake which we have committed earlier. Now, we have raised an issue regarding the jurisdiction of the court tribunal that he is not a workman. I think I have a good case. Now, the point is we have paid him 22 lakh rupees for 17B.
We will decide it whenever.
Your Lordship, but Your Lordship asked me the question that will it come back? The question is, if Your Lordship holds that he is not a workman, he would not have been entitled to 17B either. So that we missed out. He is unjustly benefited.
There is no such law under which 17B amount can be repaid.
Yes, my Lordship, I have to argue if Your Lordship sees now in this case it is academic, it is only a workman who will get it. If he is not a workman, he will not get it. That is a question. He was a sales representative, drawing a huge salary of 50,000, he becomes a workman. So today he is benefited because of this 17B. Anyways, that order was not passed by Your Lordship, that order was passed earlier. The contest should have been made by us earlier.
All orders are passed by the court only.
Yes, ma'am. Yes, earlier. I'm saying not now.
And you see,
earlier.
the most important thing is that if there is an issue of this nature pending before this court, you should insist that it should be decided at the earliest.
Absolutely. That is what I'm saying, that we should have done it.
You just allow the time to pass by.
100%. I'm saying I'm taking it on us, I'm taking it on us as the petitioner before Your Lordship.
Records have come.
Records have not been summoned, I am otherwise ready with list of dates and compilation judgments, etc.
Are you ready? After having 17B, you are not interested?
No. That is
so
not
you argue.
Lords, I have to file counter affidavit to that extent. It may be posted on Tuesday next week, my Lords.
Counter affidavit?
Yes, Lords.
You will have 17B and not file counter affidavit?
No, my Lords.
So far?
No, that is not the case, my Lords.
Then?
They have filed, basically I have filed with regard to the, my Lords,
back
Non-grant
wages.
of back
I have
wages.
filed with regard to back wages, a writ application, and subsequently what management has filed with regard to reinstatement writ. So my submission to that extent with regard to reinstatement writ petition, may I be permitted to file the counter affidavit? I'll be filing on Monday, it may be posted on Tuesday. This is my humble submission.
My writ petition is of 2019, the first one. His writ petition is subsequent. We cannot go beyond the record.
No, my lords, actually the workman has filed it in person. Earlier he filed it in person and subsequently I was provided with the Wakalatnama. I have been instructed that now I will be filing. I am having my counter affidavit. It's ready, but today it cannot be filed. I will be filing it on Monday. It may be posted Tuesday. I will be ready to that extent.
I don't understand. Such strong orders are passed in your favor and you have not
Yes,
completed
my
the pleading.
My lords, what
It
my,
goes, very seriously against you.
My lords,
So
my
your conduct
submission-
is not above the board.
May I please, my lords?
You are moving your contempt application and you do not complete the pleadings.
Reason, my lords,
What reason can come?
May I please be permitted, my lords? My lords, what the order of 17B is way back of 3-4 years back, my lords. Now they have complied. That I agree, my lord, to that extent. But at least I have to file a counter affidavit. I am ready with my draft, my lord, but it couldn't be filed today because the matter is on the board today, my lords. May I be permitted to file it on Monday? It may be posted on Tuesday.
Are you an income tax paying?
Yes, my lords.
File your returns. File all your returns for the entire period.
My lords, my lords. That I will convey to my client, my lords. That I will convey.
That has to be filed. आप नहीं करेंगे तो पैन नंबर दीजिए हम लोग मंगा लेंगे.
कर देगा. I'll ask him.
Because your statement that you are not gainfully employed anywhere is a very serious statement.
That is provided, my lords. That is there, and that is in the affidavit.
Maybe affidavit. You file your income tax return. We want to see your income.
My lords. Well, that I will be filing. And he has provided that he is not employed anywhere in the affidavit that has been filed as a witness before the tribunal, lords. It is categorically been provided.
We'll see that.
My lords.
Because income tax return is your own document.
Yes, my lords.
Isn't it? You can't deny that if you disclose any income.
No, my lords. That is the case. I'll be asking him. I may be permitted to file.
आज के बाद आप लोग 17B में you should ask all the
Yes.
parties to file income tax returns.
We should not only that, we have to be more, it is taken as a matter of course. I have seen
Yes.
17B, the clients, the lawyers, we take it as a matter of course. It should not be, because it causes today I understand
It
because
is a very important disclosure, which is absolutely within their own knowledge. They are bound to disclose it.
not only income tax, that is again a self-disclosure made. One must say that if I have to support a family, how am I supporting it?
No, not that.
Well, it
But
is a
at
matter-
least if some disclosure is made in the returns,
They
it is
will all file
something.
zero return. That
They
return.
will file, they will not file. They have all parallel work.
Whatever
going
is my only concern is today twofold.
Do you want to have their income tax returns?
Because I have been instructed yesterday and we should have filed an affidavit application. By mistake, without deducting TDS, the entire amount is being given. So he may just take care of the 2,20,000. It's a thing which he should be genuinely, it will not go to us asking for a refund. He may have to return it so that we can pay it to the government while file an application. He will take instructions from his client to that effect. At least not say that I have now.
And not only that instruction, you have to disclose the PAN number also.
Yes.
My lords.
Because they will have to credit it to the department.
That amount, we'll have
That
to.
amount you have to credit it
Yes,
to the
yes, I cannot
department.
retain it. It's an offence. It's an offence. And then not if he has filed everything in his writ petition. Fortunately, he's filed all the deposition, everything. Records are complete. We can argue it out. It's a pure question of law, according to me, on jurisdiction. Because what has
But
happened
what
is
will happen to 17B?
now that question will be
Okay.
because that order we have accepted, we can't go back. I'm just indicating my fault on that day. There are three things which you actually bear in mind. One is a very interesting issue. The tribunal says that he did not plead or prove, lead evidence that he's a workman. But the management witness was asked 5 questions. Does he have supervisory powers? Can he grant leave? Can he issue checks? These were answered in negative. Therefore, he's a workman. Now, the burden of proof has been completely shifted on me. And there are judgments that just because you come out of these things, you're not supervisory or you have the power to issue, that does not become that you're a workman automatically.
It was a reference case.
No, it was a 2A directly. See, he challenged his dismissal under 2A. So it was not a reference.
So therefore, it was for him to at least
Establish.
assert that.
Yes,
At
yes,
least assert.
Assert. So that's the basic.
He must have said so in his
No,
2A
the
application.
tribunal says that he has not said so. Except that I am a workman. How is a workman? There is no pleading, there is no evidence. So today, if I had not appeared, the tribunal could not have granted it.
He had said that he is a workman.
One. That
That
is
is
a formality. No, that's not the way. How is it? Because his designation is representative. He is a sales representative. And there are judgments of the Supreme Court that medical represent sales representative or not. Number two, the issue is that he was a probationer. Now I have dismissed him or relieved him by exercising my right under the letter of appointment, the contract. Now I come on the exception of section 2B, OOBB. OO is retrenchment and AB, BBC are the exceptions. That the trial court has relied upon a judgment passed prior to the amendment and said no, this will not apply. So this on the face of it, the award is not correct. My only contention is I filed an application for stay of the execution proceedings downwards because I have complied with 17B. That may not proceed to the next stage.
Because it is posted today.
Yes, it is posted. So I was being compelled. So let that stay of execution happen.
What is
And the
execution
contempt can be
case
dropped.
number?
Yes.
And pending before whom?
Yes. It is pending before the Labour Court, Jamshedpur. And the execution case number is 113 of 2022. We have filed an application in 4378, writ petition 4378.
G. 4378.
IA number 3568.
There are 2 3 One is the contempt is now required to be dropped.
Yes,
That is
I think you should not insist contempt.
It is absolutely between you and the
court. Yes. Me and
between he and the court. So therefore, now contempt is required to be dropped. Right? You have complied to order. There may be many reasons, but we are not inclined to proceed any further. And so far as this IA is concerned, what is the execution case number?
Case number is 113 of 2022.
Where is it mentioned?
You have any contempt petitions?
When there was an order of 17B, the award was not stayed.
No, award was stayed, but since we did not, it's a conditional order. It was a conditional stay. We
Since
did
you
not,
did not
pay
pay
the levy and execution fees. That has to be stayed because there is no order of stay of execution. Because now the stay will
But
revive.
the stay will be subject to the condition that you still continue to abide.
Yes, per month.
But we'll decide it if the
Yes.
board remains, we will decide it.
Correct.
Sure. पहले contempt for contempt civil number 341 of 2022. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the order dated 9/12/2019 with regard to payment to the respondent workmen under section 17 capital P of Industrial Disputes Act 1947 has been complied, and an amount of rupees 22 lakhs and odd with arrear and up to date.
Yes, up to March. 10th April.
Up to the month of April has been remitted to the account of the respondent workman. He submits that on account of some confusion, the order could not be complied. He has also submitted that the core issue involved in the present case is that the respondent is not a workman at all. The learned counsel for the opposite party has submitted that the learned counsel petitioner submits that the contempt proceedings may be dropped. The contempt case may be dropped. The learned counsel for the opposite party does not dispute that arrears with up-to-date payment up to April 2024 has been received by the opposite party. However, he submits that at this stage, the merit of the case may not be entered into. He also submits that it may be observed that the petitioner would continue to abide by the order of this court during the pendency of the present case. He has also submitted that he seeks only one indulgence to file necessary counter affidavit, and otherwise, and on the next date, he will prepare himself for the final disposal of these matters. Considering the aforesaid submissions and the order dated 9/12/2019 having been complied by the petitioner, though belatedly, this court is not inclined to proceed any further in contempt case civil number 341 of 2022, and accordingly the contempt proceedings are hereby dropped. However, it is made clear that the petitioner would continue to abide by the order dated 9/12/2019 passed in WPL number 4378 of 2019 during the pendency of this case. ये हो गया contempt का काम. IA number 3568 of 2024 in WPL number 4378 of 2019. The learned counsel for the petitioner has submitted that since the order passed by this court in terms of section 17 under section 17B has been complied, though belatedly, the execution case being execution case number 113 of 2022 pending in the court of learned presiding officer Labour Court Jamshedpur be stayed. He has also submitted that he is also ready to argue the case finally.
Yes.
The learned counsel for the opposite party has submitted that the next date in the execution proceeding is tomorrow.
Today itself.
Is today itself. Today is the date fixed in the execution case. After hearing the learned counsel for the parties and considering the facts and circumstances of this case and the fact that the order passed by this court with regard to payment under section 17 capital B of Industrial Disputes Act having been complied though belatedly, the execution case number 113 of 2022 said to be pending in the court of learned presiding officer Labour Court Jamshedpur is stayed till the next date of hearing. दो केस क्यों हैं?
One by us, one by him.
We'll call for the records. That is better.
That is better.
Otherwise, counter.
Or I was proposing that jointly we can prepare a compilation of the pleadings and the evidence and probably you'll also summon the records and we'll also produce file. Jointly we prepare one compilation.
Let the records of the learned court, let a photocopy of the records of the learned court in connection with the award dated 8/5/2019 passed by learned presiding officer Labour Court Jamshedpur in ID case number 3 of 2015 be called for. आपको किसमें काउंटर फाइल करना है?
WPL number
9/24/2020. Let the counter affidavit in WPL number 9/24 of 2020.
Sorry, it's 4378.
Let the counter affidavit in WPL number 4378 of 2019 be filed by the respondent. How much time do you need?
Unless I'll be filing that on Monday.
By Monday?
March.
These cases are assigned to this bench.
No, WPA.
Let the matter be placed for Monday would be 18.
It will be 15.
So this month is Monday.
It will be 15.
Will be 15. है ना?
Yes, yes.
15th of April.
आ जाएगा रिकॉर्ड 30 तारीख तक.
हाँ हाँ. Jamshedpur anyways.
Let the case be fixed for final hearing on 30th of April 2024. To be taken up at 2:15. Let this order be communicated through fax.
One indulgence, but I am told that the execution has now been transferred to the civil judge senior division. So you also be like presiding officer, labor court, or the transferring court even.
Or any other court
In session.
to whom the execution
Has been
case may have been transferred.
Great.
Let this order be communicated through fax. You prepare your compilation.
Yes, I'll prepare my compilation and I'll give it by 29 minutes. 30th is the matter. Before that, your also wants us to give it.
26 तारीख को आपको चाहिए.
हाँ, 26.
Weekend I need.
हाँ, ठीक है. 26.
You will file your written submissions also.
Yes, short submissions for arguments.
The councils are directed to file their short submissions of argument, list of dates, and judgments which they seek to rely upon, along with a common convenience
The
compilation.
list of dates should also be common. There is no dispute or fact. Submissions are different, but I think we should not trouble your with two list of dates.
Yes, it
हाँ,
will be a point.
हाँ,
Debt which are jointly filed.
हाँ, list of dates has to be common.
That will be common as submission.
We'll work it
And
out.
if you file a convenience compilation jointly,
Yes.
giving your different respective submissions and the judgments, then it
Now,
will
what
be
I
easy.
propose is list of dates and the convenience compilation in one. Submissions will separately will give
Yes.
it with our judgment. So that
That's
makes sense. Once your lordship is through the records, then the submissions will make sense. Great.
Under we should we change the heading under the heading for final disposal कर देते हैं? I posted for final disposal.
Yes, because one call was defect. I think the defect.
Final disposal to be taken up at 2:50. Isn't time मत मांगिएगा.
नहीं
फाइल पढ़ के आएंगे
Monday
टाइम मत.
Monday फाइल का काउंटर आएगा.
For orders item 7 criminal division 261 of 2019.
Yes, petitioner.
In this case, the whole IA that is filed for exemption from surrender. On the ground that this petitioner was convicted under section 498 IPC, and my lord, the complainant has deposed in course of trial that she is ready to reside with her husband, and there was also a compromise. There is chance of compromise between the party and settlement, my lord. Therefore, I pray, my lord, the petitioner may be exempted from filing, and notice may be issued to the complainant.
आप तो कंप्लेनेंट को पार्टी नहीं बनाया तो किसको नोटिस करेंगे? लिमिटेशन भी है आपका. किसको हम नोटिस करेंगे?
Limitation is my lord.
आप बोल रहे कॉम्प्रोमाइज हुआ था. कहाँ से बोल रहे कॉम्प्रोमाइज?
डिपोजिशन से हम पढ़ लेते हैं इसके
रिकॉर्ड नहीं है ना मेरे पास.
ऑर्डर
कहाँ
में
से
दिया
बोल?
है एमपी जज
आपका ये जो एग्जेम्पशन फ्रॉम सरेंडर है ना,
जी
2019 से चल रहा है कहानी, है ना? यू हैव टेकन द कोर्ट्स आल्सो फॉर ए राइट, एंड पब्लिक बोलेगी कि 2019 से सरेंडर नहीं किया.
if the notice is my lord issued to the complainant,
Why? What were you doing since 2019?
ये पेज नंबर 13 हम पढ़ते हैं.
What were you doing since 2019?
Page number 13 पढ़ते हैं. She denied the suggestion she is treated by doctor. Further, she admitted she want to live with her husband and in-laws.
No, we will not give you any time. On 24 to 2020, 2 weeks time was allowed to you to remove the defense. And thereafter the case was IA was filed.
No.
2834, and it was also indicated that failing which the case will be dismissed.
That was there, but
right.
But 159 petition was filed thereafter.
That's right. When did you file it?
That was filed
After 24 to 2020.
That was filed on 23/9.
Then why the office did not dismiss your case for default?
Because since the petition under section 159 was filed.
When was it filed?
It was filed on 23/9/19.
IA?
That is IA.
IA was filed on 16/3/2020. After the order, 24 to 2020.
One is the matter. One is the 16/3 is the revocation petition.
No, IA CR number 2835 of 2020. No. This petition was filed after the preemptory order granted by this court. I will not allow this. आप बस सरेंडर करके आइए, फिर आपका कहानी सुनिए. ये केस डीएफडी हुआ कैसे नहीं हमको समझ में नहीं आया. आप जरा रिकॉर्ड देख के हमको समझाइए, थोड़ा हाई कोर्ट का रूल समझाइए, इनको जरा दीजिए. नहीं, आप जरा पहले आप देख लीजिए, बिना देखे मत सबमिशन करिए. आप हमको डेट बताइए कि एग्जेम्पशन का पिटीशन जो है हाई कोर्ट के ऑर्डर के बाद फाइल हुआ था कि पहले फाइल हुआ था, टाइम के बाद फाइल, जरा चेक कर लीजिए. कॉल करिए, टाइम पीरियड देख लीजिए, कब फाइल हुआ था, नहीं हुआ था. वैसे तो द ऑर्डर हैज ऑलरेडी टेकन इट्स इफेक्ट.
In this case, under section 138, 1 year punishment remains 6 months. Then he was granted provisional bail for 3 months. As far back as on 7th October 2021. Now, Lord, I am not in contact, so my earnest prayer would be that you Lordship may direct the local police to take appropriate action.
आप सरेंडर नहीं किए हैं?
वही हम मुझे उसका फोन नंबर था चेंज हो गया, हम ऐसा चिट्ठी भी लिखे हैं उनको, लेकिन हमको पता नहीं है.
हम कुछ केस डिसमिस कर देते, अपने आएगा.
केस डिसमिस करने से बेटर होगा.
आपके पास इंस्ट्रक्शन नहीं है उसको केस फाइल करके, दैट इज बेटर. आप सरेंडर करके अपना पिटीशन रेस्टोरेशन के लिए फाइल करेंगे, तब हम सुन लेंगे.
मुझे तो लिख दिया जाए मेरे बारे में.
हम लिख देंगे आपके बारे में, जो जो आप बोल रहे हैं सब लिख देंगे. आपको प्रोटेक्ट करना तो मेरा काम.
नेक्स्ट वीक में रख देंगे.
कुछ नहीं, कोई नेक्स्ट वीक कर. अब आपके पास कोई कांटेक्ट ही नहीं है, तो हमको
कांटेक्ट नंबर था वो लग नहीं रहा है.
वेरी गुड,
आज लगा है, कोशिश की.
कोई बात नहीं लगेगा.
नेक्स्ट वीक में सिर्फ
नहीं
पासवर्ड फॉर डे कर देंगे तो भी शायद हो जाए. 1 महीना 1 साल सजा में वो 6 महीना ऑलरेडी रह चुका था, तब उनको मिला है 3 महीना के लिए.
और 6 लाख रुपए फाइन देने को भी कहा गया था.
कहा नहीं गया था, जजमेंट में फोन पे हाई कोर्ट से कोई ऑर्डर नहीं.
प्रोविजनल बेल हुआ था आपको? कब
इसीलिए
हुआ
कर रहे हैं.
वेयर इज द ऑर्डर?
दैट इज 7th October 2021. 7th October 2021.
That period has expired, no?
Yes.
Criminal Revision number 342 of 2022. The learned counsel for the parties are present. It has been pointed out that the petitioner was granted provisional bail for 3 months by the order dated 7/10/2021.
And I don't have any instruction whether he surrendered or
Just a moment. And today, when the case is taken up, the learned counsel for the petitioner, Mr. A.K. Sahni, has submitted that he has got no contact with the petitioner, and therefore surrender certificate has not been filed in spite of the period of provisional bail having been expired. Considering the aforesaid submission, the criminal revision number 342 of 2021 is hereby dismissed for want of surrender certificate. Let this order be communicated to the concerned court for taking immediate action against the petitioner so that he serves the sentence awarded to him by the learned court concerned. They are total.
Order for preemptive order was passed from number 22 to 20.
22 to
20. And thereafter,
how much time was granted?
There were 2 weeks time was granted.
2 weeks. When did it expire?
And thereafter, the same was filed, my lord.
When did this period expire? 7 तारीख 7/3 28 दिन होता है तो 8 तारीख मान लेते हैं।
ऑफिस में जो लगाते हैं इसमें 16/5 16 मार्च मतलब
16 मार्च कैसे 2 वीक्स है ना टाइम इसमें, तो फिर 16 मार्च कैसे हो जाएगा? आइए कब फाइल किया? 16 कब आप आइए फाइल किए?
63.
Order had already taken its effect by this time. Preemptive order तो effective हो गया था।
उस समय what will be the reason? Duration हो सकता है, छुट्टी हो सकती है, हम नहीं जानते हैं, जानना पड़ता है।
इसमें कोविड पीरियड भी नहीं था। कोविड 21 मार्च से शुरू।
कोविड पीरियड बोल रहे हैं, होली वगैरह का छुट्टी हो।
आपका काम है बताना भाई। I will not allow this kind of tactics. ये सब आपका काम है बताना। आप आइए इस पे हम सुनेंगे और यही सब लिखा के हम आपका आइए डिसमिस करेंगे। वेरीफाई के सेकेंड हाफ में आइए और क्या वेरीफाई करना है? रिकॉर्ड यहाँ पर है, जो वेरीफाई करना है।
छुट्टी वगैरह
छुट्टी के बाद कौन सा छुट्टी?
वो छुट्टी जैसे कि
आप अपना कैलेंडर लेके आइए ना, कैलेंडर सब पब्लिक डोमेन में है, आप कैलेंडर लेके आइए। 20 तारीख 2020 का कैलेंडर लेके आइए। यहाँ पे तो ऐसे भी इंस्टेंसेस आ रहे हैं कि ऑफिस सरेंडर सर्टिफिकेट के बारे में पॉइंट आउट भी नहीं करते। आपने नहीं, आपके केस में नहीं, औरों के केसों में हम देखें।
Item 9 civil review 11 of 2022.
Notices have been validated, and Wakalatnama has been filed by 6 to 9 and 11 to 13.
What about 10?
10, the notice has been served through the brother as per the records in motion.
Are they related to each other?
Yes, Your Ladyship. The order was passed in favor of dead persons, and therefore the civil review was filed. And on last date, there was a direction to the state to file counter affidavit.
Can we take the order as the notice as served to the brother, full brother, they say?
There are altogether
Notice has been served to everybody. Notice has been served to everybody.
and we have appeared also. Except 10, all have appeared, and 10 has died. 10 fellows, Virsa Urao has died. The instruction which we have
Take
received.
steps. The learned counsel for the parties are present. The learned counsel for the respondents has submitted that respondent number 10 has expired, and therefore the notice served to his brother cannot be accepted as valid. Upon this, counsel for the petitioner, इनका legal years का नाम दीजिए जब आपको इतना information मिला है तो।
इंस्ट्रक्शन लेके दे देंगे उनका.
The learned counsel for the respondents has also submitted that he shall provide the details of the legal years and successors of respondent number 10 to the counsel for the petitioner for taking appropriate steps. In this case, he shall do the needful by कब तक कर लेंगे आप बताइए? 30 तारीख तक?
2 weeks के बाद.
30 तारीख? By 30th of April 2024.
उसके पहले हम.
Thereafter, the petitioner may take appropriate steps. Pose this case under the heading for orders on 10th of February. 10th of May. अगर हो सके तो उनकी तरफ से वकालतनामा मिले तो आप ले लीजिए जिससे कि देखिए एक्स पार्टे ऑर्डर हो गया है जो भी है. Some of them had died. Nobody pointed out that somebody has died. Maybe even if the same order is to be passed, एक बार को तो रिकॉल करके सुनकर ही ऑर्डर करना पड़ेगा.
पार्टी ऑर्डर नहीं हुआ है ना. That is not correct. पार्टी
भाई
ऑर्डर नहीं हुआ.
नहीं हुआ लेकिन काउंसिल ने नहीं बताया कि अब कोई मर गया. तो नहीं ना कांटेक्ट नहीं रहता है, नहीं पता होता है.
At the time of orders passed by the honorable court, both party had appeared.
That's right.
And none of them had
How
been.
the councils would know that somebody has expired?
No, we're not.
So therefore, on that technical ground, the order is required to be recalled and reheard. Maybe that we pass the same order, but it's not.
Maybe modify. They have prayed for modification of the order.
They have not prayed. They have prayed for review of the order.
Review.
Review. Recall / review को फाइल किए हैं, recall को delete कर दिए.
All right on that.
For admission item 10, the case 1642 of 2018. Item 10.
What is it?
This is regarding promotion from the date when
CS.
Yes, CS.
Have they rejected your claim?
No, they have not considered in time, my lord. Therefore, this writ petition has been filed because when the case is
Who will consider it?
The petitioner never applied for.
He'll apply. कहाँ पर apply करना है?
No, that scheme is already over. Now she is already an associate professor at IIT.
Okay.
So
her right to claim under this scheme is
she was also
forfeited.
claiming to yes, that is no longer in existence.
No, it is one thing to say that the scheme is no longer in existence for new applicants. If the scheme is in place in a particular period of time and if a person does not apply for it, then the person is not entitled. Was there any reason an application was to be filed?
Yes.
Where is the scheme?
Yes, that I have annexure 4, page 43 of my writ petition. Implementation of CAS for faculty.
Where is the requirement to file
yes,
an application?
this is page 44.
I'm here.
Page 44, point number 3. An assistant professor possessing the degree of PhD in the relevant discipline and with regular service of 3 years at AGP of 8,000 per month shall be eligible for moving to AGP of 9,000 TM and shall be redesignated as associate professor. So this rule nowhere stipulates that there is any requirement of filling any form or any other essentials were narrated in this circular manner. So, but despite that, when I became eligible for CAS scheme, because in 2009 when this CAS scheme became operational.
Shall be eligible for moving to?
Yes. For moving to AGP of 9,000 as an associate professor. So, an assistant professor who remains for 3 years on the post, he or she shall be considered for next, that is associate professor after 3 years as per this CAS scheme alone. Now what happened ki thereafter I duly applied this letter.
When did you apply?
Yes. This is annexure 13. This is annexure 10, page 54. 17th April 2013 I applied, my lord. that it is to state that I have completed 3 years of assistant professor on so and so date and may be redesignated as an associate professor PY4 as per rules. This letter is also received. So I duly informed them that yes, now I have become eligible for CAS implementation. Therefore, my case should be considered. And
when was this scheme discontinued?
yes, this discontinued on 6/9/13 after implementation of 4-tier flexible faculty structure. 6/9/13. This CAS scheme abolished, and I became entitled with effect from 9/4/13. I also wrote this letter, and after this also, my lord, if my lord produces the next 11 series, page 55 onwards, several persons, these 2 persons have been granted after my application. They were my batchmates, and they have been considered. But my case has been left out without any.
Who are those persons?
Yes, Annexure 11, page 55 and 56, Dr. Mukul Kumar Das and Dr. Sagar Pal. These 2 persons are my batchmates, and their case has been considered for CAS after my application. My case, despite my application, was not considered, and their cases have been considered. Now,
They became eligible with effect from 12th August 2012. One was eligible from 24th September 2012, and you were eligible from
9/4/2013.
They did not consider your case.
No.
No order was passed.
No order was passed.
What is their stand in the contract?
Yes, one annexure I want to place, my lord. If my husband made a complaint before the ministry, my lord, and thereafter a committee, 5-person committee was constituted. Now, what that committee said, that is very important. This is page 59 onwards, my lord. Report of the committee.
Yes.
I would like to straight away go to page 62.
How are you concerned with this report of committee?
Yes, that I will place after reading one paragraph, how I am concerned. Just one paragraph I want to place from page 62. What is the reason which they are assigning?
You forget about these reasons.
Now
These are absolutely irrelevant reasons.
The eligibility which my learned senior friend is saying that person has to apply.
His only opening sentence was, the scheme is no longer and therefore you are not entitled. So I want to know whether any right crystallized in your favor while the scheme was in vogue.
Yes. So regarding that.
Let me hear him and then I'll come. Yes, what is your stand? Why that is the only reason you have not considered it? Yes.
That application has to be submitted for consideration for upgradation to the post of associate professor or professor under the CAS. Now the CAS was there for a limited period, career advancement scheme. Now we have a 4-tier, a different scheme altogether by the University Grants Commission. Now let us see whether a person is eligible on just completing or he or she has to apply.
She has applied?
No, that is not an application. What is more required is, kindly see, I have annexed a document.
If that is not an application, was it not your duty to tell them that this is not an application?
The scheme was already there in place. I have annexed the copy of the scheme.
What was it that was required to be placed by
Yes,
you? How do you say that this is not an application?
Yes. I just placed that.
प्रोफेसर को लॉयर नहीं समझिए ना
जी
प्रोफेसर को प्रोफेसर समझिए सिंगल ट्रैक माइंड होता है
हाँ।
अपना सब्जेक्ट के अलावा कोई चीज समझ में नहीं आता
नहीं आजकल देखते हैं कितने लोग हम लोग का खाली प्रमोशन का ही केसेस आता है
वो केसेस की बात जेन्युइन लोगों का काम नहीं करते टीचर्स एंड डॉक्टर्स का काम आप लोग को रोकना नहीं चाहिए
नहीं हम लोग रुकते नहीं
लग
इसके
रहा है
बाद में प्रमोशन हो भी गया She has already been promoted as an associate professor.
But she has been subjected to some loss because of non-consideration of.
In 2019, she has been promoted.
Yes, because she applied.
What will happen to this intervening?
13 to 19.
No, intervening period if she is not eligible. Now she says she is eligible, but she has to make an application.
आपने
And it has
form
to,
भी नहीं दिया है।
application has to be placed before a screening committee.
ये रजिस्ट्रार साहब के पास जो इन्होंने अपना वन लाइनर एप्लीकेशन आप के में कहीं लिखा है कि what are the disclosures one has to make?
The scheme is already there.
She says that I am eligible. All the material is available with the registrar. कौन सा चीज है जो registrar के पास available नहीं?
तो अप्लाई तो करना पड़ता है.
Apply और कैसे apply?
आज जैसे हम एलिजिबल हैं किसी चीज के लिए, हम सीनियर के लिए अप्लाई नहीं करेंगे, कोई कंसिडर करेगा क्या?
अप्लाई कर देंगे कोई फॉर्मेट देखिए सीनियर के लिए अप्लाई करने के लिए देयर इज अ फॉर्म. Is there any form prescribed?
I'll just show
Rather,
you.
it does not even say that one has to make an application.
No, I have annexed the entire UGC regulation, which contains the details that are to be submitted, Manoj. That is a 2-page document. Kindly see the document. Now, what is required to be submitted? Let me place that. Paragraph 5 of the counter affidavit. Firstly, we will see paragraph 4. It is stated that a petitioner was required to submit an application with all requisite details so that her eligibility could have been ascertained and she would have been called to appear before the duly constituted selection committee for consideration of her case. Since the petitioner did not apply with requisite details when the career advancement scheme was in vogue, that is prior to 6/9/2013, the date for which 4-tier flexible cadre structure came into effect, replacing the caste scheme, and therefore at this stage, when the scheme is no longer in existence, the claim of the petitioner is not justified. Then para 5. It is stated that for promotion as associate professor under caste, the petitioners were required to submit an application with all requisite details. The petitioner did not submit the same while so and so. The date for which, then the next paragraph. As regards Dr. Sagar Pal, Dr. Amit Rai Dikshit, Dr. Shushanta Sarangi, and Dr. Mukul Kumar Das, all of them applied for promotion as associate professor under caste with all requisite details. They also appeared before the duly constituted selection committee, and on being recommended by the selection committee, the 4 have been named. 4 above named assistant professors were promoted as associate professors under caste. Thus, there has been no breach or violation of so and so. The petitioner is not justified in submitting that she has been discriminated vis-a-vis other assistant professors who have been promoted as associate professors. It is reiterated that the petitioner did not submit her application along with all so and so. It is also submitted that the claim of the petitioner is not correct to the extent that mere completion of 3 years regular service in pay band 3 with ACP of ₹8,000 makes a faculty member eligible for promotion as associate professor. It is submitted that this is only one of the criteria. In addition to the above, there are other requirements: number of research papers published in reputed journals, number of PhD guiding number of researchers, consultancy projects completed on doing so. The candidates were required to furnish all such details to the competent authority for consideration of their cases for promotion as associate professor. The petitioner did not submit the same when the case was in vogue. The claim of the petitioner that there was neither a selection committee nor the promoted faculty members had appeared before any interview board for promotion to the next higher post of associate professor is not correct and hence denied. The faculty members named by the petitioner, that is Dr. Sagar Pal, Dr. Amit Rai Dikshit, Shushanta Sarangi and Dr. Mukul Kumar Das appeared for interview before a duly constituted selection committee, as is evident from the minutes of the selection committee of its meeting held on so and so. Now let us see Annexure B. Kindly see this document. Annexure B is at page 22. This is minutes of the meeting of the selection committee for the post of associate professor in the Department of Petroleum Engineering under Career Advancement Scheme, cash, in the pay band so and so. Now these are the members of the selection committee. After scrutiny of applications received for the post, the following candidates was found eligible and was called for interview. Dr. Chan so and so, So this is one. Then we have the next one is at page 23. Then the third person is at page 24. Then the fourth person is at page 25. Then another is at 26. So these are they applied, their cases were placed before the committee, duly constituted for screening. They have made recommendations after interview. So that is the request. So what is required, it is there at page number 101 of my counter affidavit. Can you see that? This is UGC regulation which contains the appendices and how it has to be applied. Like for example here, cash is at appendix 3, where it is dealing with the procedure for the first item is performance-based assessment scheme and annual performance indicators for direct recruitment and promotion under career advancement scheme. So this is the whole scheme is there. And now if we turn to page 137, the scheme is there.
Where is it?
Just a minute. Now there are tables after tables. If we see this, we would find that what else requirement is page 138. If we see, marks are there. Then what are the documents, number of publications, what will be the marks that will be scored for publication in Gazette, in their
So when
journals?
you say that publication etc. was required to be considered for CAS because the scheme is not disclosing anything.
No, this is the scheme, but I am showing to
the
your lordship.
scheme that he has that
No,
you
that
have
is, that's a 2-page document. Now this is the UGC regulation of 2010, which contains all particulars relating to different kinds of promotions, appointments and other
This
things.
is 2010.
2010.
What is the date of the CAS scheme?
This is
2009. Cash scheme 30/12/2009.
And this contains, this is Annexure C, dated 30th of June 2010. Now this contains all the particulars that have to be seen for the purposes of CAS.
When this scheme is there on 30th December 2009, the persons are to apply as per the scheme. You can't say that this is not a scheme. This is
No, I say that it is a scheme, but from time to time, directions are being issued. Also see kindly, there is a reply filed by me to the rejoinder. There I have an extra document.
No, first you see, you stick to your counter first.
Yes.
I want to see, as per this counter, which all documents he was required.
I have said so.
No, not from the counter affidavit statement. I want to see from the scheme.
The scheme.
Yes.
The scheme is the 2010 UGC regulations.
So which all documents that she was required to file, as per this annexure that you have filed.
Kindly see, Mallards, I have filed another document, Annexure D at page 15, to my reply to the rejoinder. page number 15.
Page number 12. Reply to
Reply to the region.
page number 15.
15. That is annexure D. Procedure for selection of faculty under cash. The UGC regulations 2010 gives out the norms to be followed for promotion of faculty under cash in general. However, it leaves scope for institutions to instill modalities to be followed for the procedure of selection. The committee ordered by the director has recommended a draft procedure to be followed in ISM for cash promotion. Corporate as salient aspects of the recommendation are as under. Eligibility factor, faculty member will fill up assessment form and submit to the registrar. Promotion from assistant professor with AGP of 7,000 to AP with AGP of rupees 8,000 will be by review and recommendation by a screening committee. Promotion from assistant professor with AGP of 8,000 to associate professor and from associate professor with AGP of rupees 9,000 to professor will be screened by an internal committee and selection will be done following the procedure for selection of faculty members at ISM, that is seminar followed by interview. So there is neither any seminar nor interview.
It's your internal deliberation. Was it circulated?
Yes, I just showed
Where
you.
is it? No, circulation of this particular letter dated 14/12/2000.
All of them have applied.
Merely because all of them have applied is not
And
sufficient.
their cases have been
You
considered.
take a decision post facto that there is
So
a
this is-
procedure. This is post facto, 12th October, 14th
Yes.
October 2012.
Yes.
Right? There may be many candidates who might have applied between 2009 to 2012. This is a decision as late as on 14th of October 2012.
She has become eligible.
She might have become eligible at any point of time. I want to know that you take a decision that it has to be circulated and this is the manner in which it has to be filed. We take it that with effect from 14th October 2012, whosoever applied, we had to take a call in terms of this. Where is the communication of this particular procedure to the? You show me this, I will just simply dismiss this. You show me this, or you file a supplementary contract, because this is something very important. You come up with a scheme of and a manner of application after the coming into force of your scheme.
Yes.
And therefore, and this is just an internal deliberation. Therefore, this particular procedure is required to be made known to everybody by a notice.
Should have been there.
Should have been there.
Or it has been internal circulation through email.
We
or
do not
whatever
know.
it is.
You bring
Yes,
it on record. Otherwise, she cannot be. And once she files an application in the year 2013 before the registrar, if this has not been circulated, let us assume for a moment, was it not his duty to tell her that yes, this is the procedure now, and therefore you have to file as per this procedure?
Everyone knows.
Everybody knows. We don't
Like
have
our
any common
statutes.
knowledge.
Like the statutes.
No,
of
this
the
is not a
university.
statute.
Oh, this is a regulation. It is higher.
No, this is not a statute. This particular decision that a particular procedure has to be followed is your internal deliberation.
Yes.
It has some force of law, some kind of implementation, some kind of inhibition so far as others are concerned, only when it is circulated amongst the members. Failing which, how do you implement your internal circular? And reject her claim on the ground that you have not followed this internal circular?
So I have the next 4 recommendations. I've just shown annexure.
See,
B.
if everybody is doing something, that
No.
does not mean that everybody knows about it.
Now the petitioner made a submission in the writ petition that similarly situated persons who did not even apply. They
Forget
did,
about it. You just be.
I have made a submission that they applied, they appeared before the committee.
देखिए, आप एक तो supplementary factor.
ठीक है.
लेडीशिप एक पैराग्राफ बस हम प्लेस
And thereafter,
अब कौन सा पैराग्राफ?
पेज 62 का एक पैराग्राफ बस प्लेस करते हैं, सारा कॉन्ट्राडिक्टरी हो जाएगा जो भी ये ग्राउंड ले रहा है. ही सेज ये एलिजिबल एप्लीकेशन करना था. आई एम शोइंग कि 2012 के बाद ये यूनिवर्सिटी बोल रही है कि हम लोग कोई एप्लीकेशन मांगे ही नहीं है. तो अगर मांगे ही नहीं तो 2013 में बाकी लोगों को दिया आप कैसे? ये एक पैराग्राफ इनका लिखा हुआ कमिटी
2013 में दिए उन लोगों को who became eligible prior to 2012. ये भी तो इम्पोर्टेंट है ना।
लेकिन एप्लीकेशन मांगे ही नहीं 2012 के बाद में।
कहाँ लिखे?
ये पेज 62 एक बार देखा जाए ना बस, मेरिट पिटिशन पॉइंट नंबर 2। This is a report of committee, my lord. Point number 2.
Page 62 आपका read.
Yes, read petition. Page 62, point number 2 I am reading. Denial of promotion to her from assistant professor to associate professor under CAS with effect from 9/4/13. Promotion through CAS was abolished by MHRD since the introduction of 4-tier cadre structure at SM at IIT with effect from 9/6/9/13. Mr. Nurag Bey has complained that his wife was denied promotion under CAS as associate professor from the date of her eligibility. For the last time, applications were invited for the eligible candidate to be promoted from assistant under CAS on 18 October 2012. At that time, Dr. Pandey was not eligible for post of associate professor under CAS as she had not completed 3 years in AGP of 8,000, which was due only on 9/4/13, as per MHRD so and so. After this, no notification was issued to invite applications for upward movement of AGP under CAS. This was the last occasion when applications were invited by SM for consideration of promotion under CAS, and soon after that, 4-tier cadre was introduced.
ये जो एप्लीकेशन आपने मांगा होगा ना, इसमें होगा in the prescribed form.
हम देख लेते हैं.
There is a likelihood कि because this is 18th of October 2012 and your internal deliberation is 14th of October 2012.
Yes.
There is a likelihood that you might have, in that notice, you might have mentioned that you have to apply in terms of this. देखिए आप इसको. ठीक? The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner has been deprived of her career advancement in terms of career advancement scheme dated 30th of December 2009. He submits that the said scheme was invoked till 6th of September 2013, and the petitioner had applied on 17th of April 2013 before the concerned registrar, and the petitioner had become eligible under the same said scheme from 9/4/2013. The learned counsel has also submitted that there is no provision indicating in the said scheme regarding the manner or any format on which such application was to be made, and the application having been made on 17th April 2013 could not have been rejected on the ground, could not have been refused to be considered by the respondents on the ground that the same was not in proper form. The learned counsel submits that no decision or communication was made with the petitioner with regard to her application dated 17th of April 2013. And it is only in the counter affidavit the respondents have come up with a plea that the petitioner did not apply in the proper form, and therefore the case of the petitioner was not considered.
No, our submission is she did not submit necessary documents.
The respondents have come up with a case that the petitioner did not submit the necessary documents, and therefore her case was not considered. The learned counsel for the respondents, while referring to the counter affidavits, while referring to the reply on behalf of respondent number 4 to 7 to the rejoinder of the petitioner filed by the rejoinder of the petitioner dated 2/4/2014, which is the last affidavit in the present case, in the present case record has referred to a decision dated 14 October 2012 with regard to procedure for selection of faculty under CAS. The learned counsel submits that the procedure was very much in place when the petitioner had made her application on 17th of April 2013, but the said procedure was never followed. However, it appears that CAS scheme was made applicable on 30th of December 2009, and the respondents had framed the required procedure on 14th of October 2012. Upon perusal of the document as contained in Annexure D to the aforesaid affidavit dated 2/4/2024, it is not clear that it appears that the same is a deliberation of the authorities of the respondents, but there is no indication as to whether the procedure for selection in terms of 14 October 2012 was actually circulated amongst the eligible lecturers, professors,
faculties.
eligible faculty members, so as to deny the claim of the petitioner for having not followed the required procedure and having not filed the requisite documents in terms of the said procedure. At this, the counsel for the petitioner has also referred to page 62 of the petition to submit that the last time when applications were called for the eligible candidates to be promoted from assistant professor under CAS was on 18th of October 2012. But many candidates were granted promotion subsequent to the said date. The learned counsel for the respondents is directed to seek instruction and file a supplementary counter affidavit in the present case, clearly indicating as to how and in what manner the decision dated 14th of October 2012 was made known to the eligible candidates. As it is not in dispute that the scheme formulated on 30th of December 2009 was continued till 6th of September 2013. चलिए फाइल कर दीजिए. जरूर सर्कुलेशन हुआ होगा.
क्योंकि पीछे उसका जो हमने दिखाया का रिवर्स पेज में प्रोफॉर्मा वगैरह का डिफरेंस आ रहा है.
सर्कुलेशन जरूर हुआ होगा, ऐसा नहीं होता है कि नहीं होगा. तभी आपने 12 तारीख को मतलब सब्सिक्वेंटली 16 तारीख को एक बार और मांगा है एप्लीकेशंस.
हाँ सकता है.
इसी में भी कितना टाइम आपको चाहिए? अपलोड हो जाएगा. इतना हम आराम से लिखा है. ये लोग तो वीडियो देखकर भी अपना डिक्टेशन री-वेरीफाई करते हैं.
वीडियो.
हाँ, this is all available in YouTube.
अच्छा, I never saw that.
You never saw? You can see.
Oh, the camera is here.
This is uploaded in YouTube.
Okay, I'll ask.
All the proceedings are uploaded in YouTube.
That's
Every day, 10:30 का अलग, 2:15 का अलग.
ये अच्छा है.
इससे हमको बहुत फायदा हो गया. वकील साहब फालतू बहस नहीं करते. नहीं, कुछ जैसे कुछ लोग कभी कुछ बोल देते हैं uncalled for.
तो हम लोग को कॉशियस रहना पड़ेगा. ऐसे भी हम लोग.
आप तो ऐसे कभी करते नहीं, आप इतने सीनियर हैं, लेकिन कभी कुछ uncalled for सिनेरियो हो जाता है, तो अब नहीं होता है. They know. हम बोलते हैं कंसीड करने के पहले भी सोच लीजिए क्या करते हैं. Because your deliberation are in public view for all times to come. And therefore, while dictating the order also I am careful. And I always say that these are all subject to many corrections. Two things will not change. One is your submission and other is the operative portion. क्योंकि बहुत सारे judgments during the course of hearing place नहीं होते हैं, कुछ statute नहीं place होते हैं. तो हम जब करेक्शन करते पढ़ के तो हम आते ही हैं, तो करेक्शन करके वो सब इंकॉर्पोरेट करके जजमेंट को कंप्लीट करना भी ज़रूरी होता है. कभी कभी एडिशनल पॉइंट भी रहता है कुछ लिखने के लिए.
नहीं, ये एक अच्छा चीज हुआ. Then I can also see, or the clients can also see.
Anybody can see.
I can tell them कि देख लो भाई, हाँ, कनेक्ट करके ऑर्डर तो
कुछ नहीं. कभी परसों की बात है, वो मिस्टर कल्याण रॉय का बेटा वाज अपीयरिंग, तो उसका कुछ उसके एब्सेंस में कुछ सबमिशन रिकॉर्ड करके उसके जूनियर के प्रेजेंस में I had posted the matter on the next day. तो हम बोले या तो ऑर्डर अपलोड हो जाएगा नहीं तो यूट्यूब में देख लीजिएगा एंड ही सॉ द यूट्यूब एंड आर्ग्यूड द केस अपलोड नहीं कर पाए थे हम उसका ऑर्डर थोड़ा सा एडवांटेज है पोज दिस केस ऑन बताइए
फर्स्ट वीक ऑफ
ओके ऑन 1st of May
थोड़ा अर्ली
8th of May
है
8th of May 2024 and let this matter be treated as part third to be taken up as the first case at 10:30. The supplementary counter affidavit be filed latest by 6th of May. ठीक है कभी कभी टाइम फ्रेम में कभी ऑर्डर नहीं अपलोड होता है तो मान लीजिए 1 हफ्ता का टाइम दिए रिप्रेजेंटेशन फाइल करने के लिए तो वो हम अपनी तरफ से उसको एक्सटेंड कर देते हैं
नहीं अब क्या हो गया ना कि यूट्यूब पे आ गया है
नहीं कोई बात नहीं आई ऑलवेज टेल देम आई टेक स्पेशल प्रिकॉशन टू टेल एवरीबडी कि भाई जो ऑर्डर कोर्ट में हो रहा है कोई जरूरी नहीं है यू विल गेट द एग्जैक्ट वर्डिंग्स एट टाइम सपोज हम 1 हफ्ता का टाइम दिए हमको 4 दिन अपलोड करने में लग गया इट इज़ वेरी अनफेयर नो टू गिव हिम जस्ट 2 days टाइम सो कभी कभी हम थोड़ा टाइम मोड चेंज कर देते हैं ये सब थोड़ा सा करना पड़ता है क्योंकि सेम डे तो नहीं अपलोड हो सकता अपलोडिंग करेक्शन
कई बार जैसे आपने जो डिक्टेशन दिया हम भी तो नोट नहीं कर पाए शायद कुछ छूट जाए
हाँ.
अब यहाँ पर रिकॉर्डेड है तो कोई दिक्कत नहीं वर्ड हियर एंड देयर डजंट मेक एनी डिफरेंस
नहीं हमको तो ठीक ही लग रहा है अभी तक पता नहीं
आज शाम को देखिए
एटलीस्ट आई हैव नॉट lost my cool at any point of time. So, as long as the judge is cool, there is no problem. There may be heat on your side.
No, this side also if they are cool. तो
This video has made many people cool.